Pardon to mention, my lord. This is a bank matter. We have challenged the notice regarding the mortgage property, acquiring the mortgage property by the bank. Kindly, this matter will listed tomorrow.
Pardon, my lord.
The bank is the property document of the in spite of all the clear.
Pardon, my lord. This is a matter relating Surface Act, where auction is going on 25th. Can it be listed in today?
Pardon to mention, my lord. My lord, the petitioner is a 40% permanently blind and disabled person, my lord. He has applied for the OJS examination and the appropriate provisions have not been made. His representation is pending.
Criminal appeal matter, my lord. So after posted more than 11 years. And only 7 years.
I may pardon to mention, your lordship, item 32 and 33. Mr. Mishra, he has some personal difficulty. Your lordship kindly taken after.
Matter when the matter reaches.
This is a fresh matter, your lordship.
It is a fresh matter.
Yes.
Okay.
32 and
32 and 33.
yes, your lordship.
Alright. Mention is made on behalf of Mr. Marcher and for adjournment on this matter. 36 is a failure.
Oblige.
Supplementary list, item number 1.
There is no point in keeping this case, sir. There is no point in keeping this case. Almost a person who is referring. Nothing is there. No clarity. What is the prayer? What is the allegation? Yeah, Parita. Not even framed properly.
Non obvious. Requisition stance dismissed and prosecution. Yes.
Item 2.
May I please?
Union.
Yeah.
The Union of India has filed this writ application challenging the order passed by the Learned Central Administrative Tribunal, Cuttack in OA number 128 by 2022 under Annex 3 as page 95.
No, this order, last order we passed on 29.
There, the tribunal has directed to refund that amount, but we have not refunded, and they have filed content application, which is posted to 1811.
No, we put a pertinent question to you that you took time rather on that day
Yes,
to
yes.
obtain instruction as to whether the amount in question has already been refunded.
Not
to the
refunded.
opposite since
Not refunded.
60 days.
Not refunded.
Period has for this one, so has been
Not refunded.
Yes.
Because since we have filed this writ application, they are waiting for the result of this writ application. They have not refunded. Here, what happened? Originally, my lord, the
You come
applicant.
to the page number 96.
My lord.
That order you are challenging, second page of that order, 96.
My lord.
See what are the prayers.
Admit the original application after hearing the counsel for the parties.
Yes.
Be further pleased to quash the impugned order of recovery by order number so and so dated so and so at annexure A by it in respect to the applicant, and consequently orders may kindly pass directing the respondent to refund the amount which has already been recovered from the interest, grant the differential salary from 2018 to 2019. This original application was filed by the opposite party and that has been allowed, directing.
Now you come to the operative part of the order.
My lord. Page
to the paragraph number 13, then 13,
my lord,
40.
page 107.
Yes.
It is not the case of the respondents that the applicant had obtained the promotion due to mistake on his part or withholding of any information. If employee is appointed to officiate on a higher rank involving assumption of duties and responsibilities of greater importance than those of substantive post, then he is entitled on the salary of officiating post. The applicant worked in the said post after being given promotion, and therefore he is eligible to get the pay for the said post, and the recovery of the same is illegal. The citation relied on by the Learned counsel for the respondents are not applicable to the facts and circumstances of the present case, since the case of Devendra Sharma Supra relied on by the respondent is about claiming salary on the basis of forward letter of appointment. The case of Sanjay Kumar Sinha Supra relied by the respondent is also distinct, since it was about creation of post and appointment therein. In the instant case, the respondents wrongly calculated the vacancies and gave appointment and consequently reverted, which they corrected after the order of this tribunal dated 17/10/2019. In view of the discussion above, the order of recovery dated 22nd November 2021, Annexure 8 is quashed. Resultantly, the respondents are directed to refund any amount recovered from the applicant within a period of 60 days. However, the prayer of the applicant such and such is not accepted, since the applicant had not performed the duties and responsibility of the higher post of grade 2 during the period.
Only this recovery part is
Only
challenged.
recovery part.
So what is the wrong in that?
Wrong, my lord. Here what happened? He has been
No, whether it is his fault.
No.
Wrong to him, whether it was his fault.
No. What happened? It
No,
it is not.
Crux of the matter.
It is not his fault.
Then
But what happened? Here a promotion was given. Thereafter, as per the direction of the Learned Tribunal, a DPC was conducted. The Learned Tribunal has directed, if any amount has been paid, Your Lordship, the language is as per the direction of the Learned Tribunal. So he has approached the Learned Tribunal on the basis of the liberty granted by the Learned Tribunal. The recovery has been done. I am this is the
No, that is there, but subsequently he was promoted, no?
during pendency of that original application, he has already been promoted.
And that is what is written here, that you have corrected yourself.
Yes, we have corrected,
19.
but the period for which is not entailed, there is no sanction post, and as per the direction of the tribunal, we have corrected the dates, and the period for which he is continuing in the said post, only for that period the liberty was granted by the tribunal. Your Lordship, just for a moment, the tribunal order, kindly see last portion. Though these are the original applications, along with this application, the present petitioner's original application also filed, but there has also been reflected the order dated OA number 6. Lordship, last page 8.
Who are these applicants?
There are 5 applicants. There are 5 present so far this case is concerned only for 1 applicant.
No. Whether that Sarath Mishra, the petitioner, the opposite party in this petition, was a party to that.
This is the original application relied on this.
This asking a pertinent question. You are showing a particular order to us. Whether this Sarath Kumar Mishra, who is the opposite party, in whose favor the disbursement has been made, or you are challenging that recovery. So whether he is a party in this, then how the others order can be implemented against him, utilized against him?
No, this order has been reflected in this thought.
Reflected.
Yes. Your Lordship, kindly page 35 of the original application. Present and repeat.
Passed in another case, you are likely to be utilize it against this opposite party, who was not a party there.
He is also a party.
That
650 has been reflected in page 35. Your Lordship, kindly see page 35 or the writ petition.
What has been mentioned?
Page 35 of the writ application, present writ application. Then Your Lordship, page 36. Your Lordship, kindly see.
35, you are saying.
30, you have given 2 page numbers. Which one is correct? There is a middle, there is a page number, on the side there is a page number. Which is that annexure you are? Annexure
that is
copy of the original application.
That is the original application filed by the present opposite party.
Yes, page number 10
to 58. They are annexure A by 5.
So petition number 2 is there.
Petition number 2 is there. And then Your Lordship, kindly see next page 36. Next page. Number 1.
Page number 855.
Petition number 2 is Sarath Kumar
Mishra. Yeah.
Page 36 re kon hoche?
Your Lordship, kindly see paragraph number 1, last 4 lines. This common order with OA number 170 by 2018 being taken as the lead OA to other OAs, OA 650 and 651 of 2017 with similar dispute were also heard together with these OAs. So all these OAs were heard together.
All right.
Although the order of these two OAs are passed separately in view of the some factual differences, but that is the main crux of the case, my lord. There a liberty was granted. There are 5 persons, my lord. 5 recovery has been made. Reversion order was passed, 5 recovery has been made, and out of which 3 original applications were filed and 2 were satisfied.
No,
They
what
have
was
not.
the operating part in this order?
Operating part, my lord.
Para 21.
Yes, my lord.
Sir, page
Yeah,
44.
page para 21. कौन है तो अच्छी? In view of the above discussion.
Discussion, the impugned order dated 15/11/2017, Annexure A by 9 and dated 26/3/2018, Annexure A by 10 are set aside and the matter is remitted to the to reconsider the case of the applicant for notional promotion as SI grade 2, grade 3 with effect from 16/2/2011 by convening a review DPC after taking into account total vacancies available in the most cadre for the post of SI grade 2 and grade 3 as discussed in paragraph number 16 of this order, and if the applicant is recommended by the DPC for notional promotion with effect from 16/2/2011, then the respondents will allow consequential benefits as per the letter dated 26/8/2014, Annexure A by 3 of the respondent number 2. In case the applicant cannot be promoted from 16/2/2000 in any
You
of
have the
the
available
vacancies in the combined cadre as on 16/2/2011, then his case for national promotion will be considered on or after 17/2/2011 as and when vacancies of SI grade 2, grade 3 are available as per the rules prevalent during the aforesaid period. If the applicant will be found eligible for national promotion to the combined cadre SI grade 2 and grade 3 for an earlier date, then he will be assigned the seniority from the date here he would be found suitable for such promotion as per the available vacancy, and he would be allowed all consequential service benefits for such as per the rules. The respondent will communicate the decision taken in this regard to the applicant a speaking order with 4 months from the date of receipt of a copy of this order based on recommendation of the review DPC to be convened as per this order. The OA is accordingly allowed in part the CP such and such, OA number such and such for violation of the interim order of this tribunal dated be dropped as there is no proof that the respondents have willfully violated the order dated 3/4/2018 of the tribunal, taking into consideration the fact that the impugned order dated 26/3/2018 was passed prior to 3/4/2018. The notices, if any, issued to the respondent and CP numbers also are accordingly discharged. Since the facts of the other and the batch are similar to the facts
All right. So what happened after this?
After this, a review DPC was conducted and he has been given promotion from 2016.
That is what? Yes. Then?
From 16, he is continuing. But from...
No, it is on the basis of this direction. DPC was convened and he was given promotion. In the event of promotion being given, what is the mandate of this order? That he will be given all consequential benefits.
All consequential benefits have already been given.
Then what happened?
But this 650 is a part of that. So in this 650, a direction was given, last paragraph, then the respondents will not be at liberty to pass appropriate order to withdraw or disallow any service benefits that would have accrued the applicants because of the interim order dated 7/12/2000.
What is that? Which line?
That 650, which memory file. Last case. There, last 4 lines of paragraph number 12, the respondents will at liberty to pass.
So which order is to prevail? The order in which the entire OAs have been taken together and finally the common order has been passed, or this 650 individually?
This is only relevant for the
applicant.
No, this 650 and 170, all the batch were disposed of on one day, 1710.
That is all right, but it has been merged in the case that you are reading now. The very first paragraph you have read, the court has taken all together, including 650.
650. 5%.
Yes. So when that became the final order, how can you take advantage of the...
No, 650 is a part of this order because a common order was passed.
This order is passed in respect of the applicants in this 650
Right.
and 651.
Where this
Not,
application?
Sudarshan Behra and Narendra Kumar Singh.
So that is not applicable for this man,
Present
Sharat
petitioner.
Kumar Mishra.
And all these OAs taken together.
It's all right, but a similar order, if it has not been passed and it has been mentioned very clearly that whatever has been accrued to the applicants means these two ways.
Yes.
It's not that because that was disposed of in a different
Yes.
by different order. It was hard analogously, but so far as these two concerned, separate order was passed, and for the others, another order was passed. So that is very clear. There is no ambiguity in that.
He
So
can-
for which we have conducted a review DPC. Review DPC and he has been promoted. He has been promoted subsequently, retrospectively from 2016.
Yes.
But from 2014 to 2016, though there is no sanction post, since he in SI grade 2, subsequently merged with grade 3 also.
ସେଥିପାଇଁ ଆପଣଙ୍କର ପାରା 1 ରେ ସେମାନେ ଲେଖିଲେ ଯେ ଯେହେତୁ ଫ୍ୟାକ୍ଚୁଆଲ ଡିଫରେନ୍ସ ଅଛି ସେଇ ଦିଟାକୁ ଆମେ ଅଲଗା
ଅଲଗା
ନଉଛୁ
କରିଦେଲୁ।
ଏବଂ ଏଗୁଡାକ ଗୋଟେ ଅର୍ଡର ପାସ୍ କରୁ that is the basic difference.
But
You are right that ଏଇ ଯୋଉ ଶରତ କୁମାର ମିଶ୍ରର ହଉଛି OA ନମ୍ବର 170 of 2008 ତା ସାଙ୍ଗରେ ଏଇ ମ୍ୟାଟର ଗୁଡାକ ଶୁଣାଣି ହେଲା including this matter also. କିନ୍ତୁ ଏମାନଙ୍କ ପାଇଁ ଅଲଗା ଜଜମେଣ୍ଟ ହେଲା ତାଙ୍କ ପାଇଁ ଅଲଗା ଜଜମେଣ୍ଟ ହେଲା ତ ସେମାନଙ୍କ ଜଜମେଣ୍ଟ
ଏଇଟା
ଦିଆହେଇଛି ଯେ this you have been given liberty that you can withdraw the service benefits which have accrued.
Not for
That is not there in this particular order.
Had it not been so, the common order would have been there. Rightly, the tribunal has passed a
Because the
separate
factual
order.
difference.
Yes.
Take down the Union of India and others are the petitioners in this writ petition, and they have challenged the order dated 15/9/2023 passed by the Central Administrative Tribunal Qatar in OA number 128 of 2022. In the aforesaid OA, the opposite party, Sharat Kumar Mishra, inter alia, for a direction to quash the order of recovery by order number page 96 of the in that annexure 3 order number so and so dated so and so in respect in his respect and consequently to pass direction to the opposite party to refund the amount which had already been recovered from him with interest and with a further prayer to grant the differential salary for the period from 26/3/2018 to 11/6/2019, that is during the period in which the opposite party was illegally reverted. The London Tribunal, after hearing the London Council for both the parties, passed the order holding as follows, quote paragraph number 13 and 14. The Mr. Gupta Land Council appearing, Central Government Council appearing for the petitioners urged that the way number
128.
This is 128. Way number 128 of 2022 was hard. So what is that number of the way of that petitioner? You are showing that at least
The 35.
that OA number 650 of 2017, OA number 651 of 2017, along with OA number 170, along
169,
with
170.
169, OA 170, 171, 172, 177 of 2018 were heard analogously, and common order was passed so far as OA number and 651 of 2017. But so far as petitioners case, that is OA number 17, petitioner
So 170 of 18.
170 of 2018 is concerned. That is a separate order was passed. Yes.
Well, so far this
Along with
presentation is
169
concerned.
of 170.
170 is order passed.
That is at page 35.
35, 36.
35.
Annexure by
A separate order was passed, and in the OA 650 of 2017 and 651 of 2017, a specific order was passed by the Lenin Tribunal that petitioners would be at liberty to pass appropriate order to withdraw or disallow any service benefit that would have accrued to the applicants because of the interim order dated 7/12/2017 after following due process of law. And in view of such order passed by the Lenin Tribunal in OA number 6 and 651 of 2017, steps have been taken against the opposite party for recovery of the recovery amount already paid as per the order of recovery dated 22/11/2021. After hearing the Lenin Council for the petitioner and going through the order passed by the Lenin Tribunal in OA number 650 of and 651 of 2017, we found that the present opposite party, Sarath Kumar Mishra, was not an applicant in the two OAs. And in view of the specific order passed by the Lenin Tribunal, in those two original applications which were disposed of by a common order, that the uh, petitioners would be at liberty to pass appropriate order to withdraw any benefit would not be um, applicable for the um, opposite party. As in the case of opposite party, uh, whose original application number is OA number
170
170 of
2018.
2018, which was disposed of along with OA number 169, 171, 170, 177 of 2018 by a common order dated 17/10/2019. Uh, no such liberty was granted to the petitioner uh, for recovery. Of any service benefits which have already been given to the petitioner, to the opposite party. The Learned Tribunal has relied upon the decisions. Say Rafiq, सेटा
Take
realize
message, my lord.
काहे को page रे?
That is my lord. Page 99,
Page 99.
paragraph number 5,
Just
State of Punjab and other
just a minute. 99.
that are
99 ର କୋଉ paragraph?
ସେଇଠି ଲେଖିଛନ୍ତି discussed କରିଛନ୍ତି paragraph number 5 ରେ ଅଛି।
Right. The Learned Counsel for the opposite party relied on the decision of the Honorable Supreme Court in case of State versus Rafiq Mashia, reported in so and so at the IG page number 99, and wherein it has been held as follows. That is the quote further. We after going to the ratio laid down by the Honorable Supreme Court and the findings of the Learned Tribunal, we are of the view that when the opposite party has been appointed to officiate on a higher rank involving assumption of duties and responsibilities of greater importance than those of substantive post. And when he had not obtained the promotion due to his part or withholding of any information from the petitioners, and he has already received the amount, then the Learned Tribunal was justified in holding that the recovery would be illegal. We are also of the view that the Learned Tribunal is quite justified in differentiating the case of Devendra Sharma versus Swan Society relied upon by the petitioners. So also the case of Sanjay Kumar Sinha reported in Swan So, as the factual aspect in those cases are quite different. The Therefore, the Learned Tribunal is justified quashing the order of recovery dated 22/11/2021, which was passed against the opposite party. In view of the foregoing discussions, we find that there is no infirmity or illegality in the improvement order passed by the Central Administrative Tribunal Perfect Bench. Accordingly, the petition being devoid of merits stands dismissed.
Both
Yes.
2 and 3, I think, the same. 3 is also the same, no?
3 is same. That is, তার হচ্ছে ওয়ে নাম্বার
এই
72
যে
of 2018
ঋষিকেশ দেহুরির যার যে নেক্সট আইটেমটা তার ওই নম্বরটা খালি চেঞ্জ হবে ওই নম্বরটা কিন্তু
172/2018
172 না
ମାଇଲ ଯୋଉଟା 170 ଅଛି ସେ 172 ହେଇଯିବ
to 2018
18
all right, yes, next. Yes, we have already dismissed it. We find that it's a frivolous petition. Yes.
obliged.
Yes, it's all right. We have gone through it. Yes, don't record his presence and find that we find no merit in this petition. Yes, yes, yes. We have gone through it.
I will submit date check and the note.
Yes, yes. Next, item number 4.
Item 4.
Item 4, my lord. This is the second round litigation, my lord. My application has been rejected under Annexure 4, my lord. Yes, 34. Notice has to go.
Representation annexure 4.
Annexure 4, my lord.
No, representation has been rejected.
My lord.
Yes.
So, the ground given by the authority, why do how do
Overhead income rightly awarded?
No. Yes. So, what do you is the ground of your challenge?
My lord, 2 times.
No. What is the ground of your challenge to that order? How that order is wrong? Annexure 4.
Your representation has been considered.
My lord.
It has been rejected. Now you are challenging that rejection order. My esteemed brother is putting a pertinent question that on what ground you are challenging this.
My lord, compensation has not been rightly awarded.
You read the order.
Madam, this case is taken up today. The petitioner Bhimsen Seth, late Ishwara Seth, Bhimsen Seth and Bhagirathi Seth, son of all of village Bhundi Mohan, PS Bolangir, district Bolangir, are present and filed Hajira. Dr. Nutan Seth, OS, as JB Zone Officer, Bhundi Mohan, verified the record submitted by the petitioner with reference to the available officer record. The petitioner, namely Bhimsen Seth, late Ishwara Seth, Dayamaya Seth, son of Bhimsen Seth, and Bhagirathi Seth, son of Bhimsen Seth, all of Bhundi Mohan, PS Bolangir, district Bolangir, have filed the WPC number 7963 of 23 to include their names in the list of affected family in village Bhundi Mohan coming under Lower Suktel Irrigation Project Bolangir. Honorable Court Order number 1 dated 20/3/2023 in WPC number 7963 of 2023 without expressing an opinion of the merit of the case disposed of the writ petition directing the opposite party number 5 PDDR to consider the representation filed by the petitioner via Annexure 3 and pass appropriate order in accordance with the law within a period of 3 months from the date of production of certified copy of the order. The petitioner has filed this certified copy of the aforesaid order. Honorable Court in this office on 20/4/2023 basing on the prayer of the petitioner, order of this Honorable Court High Court with reference to records available and documents filed by the petitioner, the following observation is made. The rehabilitation assistance of the petitioner, namely Bhimsen Seth, son of late Ishwara Seth, Dayamaya Seth, Bhimsen Seth, and Bhagirathi Seth, son of Bhimsen Seth, all of the village Bhundi Mohan, PS Bolangir, district Bolangir, has been sanctioned by government in Water Resource Department via letter number 15,317 WR dated 21/2022 in category of affected families losing 75% of their land holding in the Lower Suktel irrigation project area. All the 3 petitioners have been already received their rehabilitation assistance detail below. 5 lakhs. Important to mention that the Bhimsen Seth, son of late Ishwara Seth, Bhundi Mohan, has owned 3 numbers of holdings in Mauja Bhundi Mohan, that is holding number 187/18 and 87/18. The total land of area these 3 holdings accord 5 decimal 5.77 decimal, out of which accord 4.12 decimal of land is acquired for the lower irrigation project. The land acquired percentage is 71.40, is less than 75%. Therefore, the entitlement of the 5 lakhs per head was sanctioned and paid to the petitioner as per provisions contained in second schedule of RFCTR Act 2013. As claim of the petitioner is fulfilled as provisions of contained in second schedule of Artificial Act 2013, no further action is required to be taken at this level. Intimate the Advocate General.
Yes. So, what is the illegality
My lord,
this
it should
order.
be twice more than 5 lakhs, 10 lakhs.
On what basis?
ଆପଣଙ୍କୁ 5 ଲକ୍ଷ ଟଙ୍କା
ଦିଆଗଲା।
per head sanction already ହେଇଯାଇଛି।
ଆଜ୍ଞା।
ତ ଆପଣଙ୍କର ଯଦି ଯୋଉ percentage of land acquired,
Madam.
if it would have been 75% or above, perhaps you would have been for that rehabilitation assistance.
Madam.
So
My
they have
grounds has been
calculated.
taken, my lord, page 11, my lord.
Yeah.
Grounds has been taken, my lord, page 11.
Let us see what ground you have taken in challenging that order.
Supreme Court judgment, my lord, one writ petition CLR 3/2/2022 reported in.
No, the decision is ma'am. What is your ground? In what way this order, a person, how who is entitled to get this benefit? You are claiming for rehabilitation assistance. Okay, money you have received. So for getting that rehabilitation assistance, whether or not that if you are to come within that category of affected families, then if you have lost 75% or above of your land, then you can only get. Is it correct or not? That observation.
ତାଙ୍କ କହିବା କଥା ଆମ କହିବା ଅନୁସାରେ 75%.
So your ground is only the decision. What is your ground? How you will make applicable the case law? What is your ground? You read what is that?
ଆପଣଙ୍କର ମୌଜା ଯୋଉ କଣ ଗୁଣ୍ଡି ମୁହାଣରେ ଯୋଉ ଜମି ଥିଲା 3ଟା ହୋଲ୍ଡିଂ ରେ ତାର ଟୋଟାଲ ଲ୍ୟାଣ୍ଡ ସେମାନେ ଯୋଉ ଦେଖେଇଛନ୍ତି ଟୋଟାଲ ଏରିଆ ହଉଛି 5 ଏକର 77 ଡେସିମଲ। ଏଟା ଠିକ ନା ନାଇଁ? ଆକ୍ଚୁଆଲି ଠିକ ତ? ଆପଣଙ୍କର ସେମାନେ ଦେଖେଇଛନ୍ତି ଯେ ଏଇ ଯୋଉ ଲୋୟର ସକ୍ତେଲ ଇରିଗେସନ ପ୍ରୋଜେକ୍ଟ ପାଇଁ 4.12 ଡେସିମଲ ଅଫ ଜମି ଅକ୍ତିଆର କଲେ, ସେମାନେ ଆକ୍ୱାର କଲେ। ଏଇଟା ଠିକ ନା ନାଇଁ? ଯୋଉଥିପାଇଁ ଆପଣ ଅଲରେଡି କମ୍ପେନସେସନ ପାଇଲେଣି, ଠିକ ତ? ତେଣୁ 5 ଏକର 77 ଯଦି ଟୋଟାଲ ଜମି ଆପଣଙ୍କର ଅଛି, ତା ଦେହରୁ 4 ଏକର 12 ସେମାନେ ଆକ୍ୱାର କଲେ, ତାଙ୍କ ପରସେଣ୍ଟେଜ ହଉଛି 71.4। ଏଇଟା ଠିକ ନା ନାଇଁ? ତେଣୁ ଆପଣ ଯଦି 75% ବା ଏଭବ ଯଦି ଆପଣ ସେ ଆକ୍ୱାର କରିଥାନ୍ତେ, ତାହେଲେ ଆପଣ ସେ rehabilitation assistance benefit ଟା ପାଇଥାନ୍ତେ। that was their scheme. So how you say that the authority has committed illegality in not granting that assistance to you? In what way?
So the factual position narrated in the decision referred to in 2017 one OLR is similar to your case?
Similar, madam.
What is that? You simply place the decision. You are not giving your facts.
Any other day, my lord, I will satisfy.
Read petition ଟା ଏମିତି ହେଲା ହବ।
ଗୋଟେ ସେଇ କେସ ର ଯଦି ଫ୍ୟାକ୍ଚୁଆଲ ଆସ୍ପେକ୍ଟ ଟା ଆପଣଙ୍କ ସାଙ୍ଗରେ
ମୁଁ ଦେଖିବି, ଗୋଟେ any other day ଆସୁ ମୁଁ ଦେଖିବି,
ତାହେଲେ ରେସିଓ ଟା ଆପ୍ଲିକେବୁଲ ହବନି, ବୁଝିଲେ ନା? ସେ କେସ ରେ ଯଦି ତାଙ୍କର ଲ୍ୟାଣ୍ଡ ଆକ୍ୱାର ପରସେଣ୍ଟେଜ ଯଦି 75% ରୁ ତଳେ ସେଠି ଯଦି ସେ ବେନିଫିଟ ଦିଆ ହେଇଥିବ, ଦେନ୍ you have a case.
I'll show, my lord.
ସେଇଟାକୁ ଷ୍ଟଡି କର ଆଉ ସେ ଡିସିଜନ ସେମିତି ହୁଏନି। ଫ୍ୟାକ୍ଚୁଆଲ ଆସ୍ପେକ୍ଟ ର ପ୍ରତ୍ୟେକ ଯଦି ଚେଞ୍ଜ ହେଇଯିବ, ତାହେଲେ ରେସିଓ would not be applicable। ତାକୁ ଷ୍ଟଡି କରନ୍ତୁ, ଆପଣଙ୍କର ଏଇଟା ଷ୍ଟଡି କରନ୍ତୁ। କେବେ ରଖିବା କୁହନ୍ତୁ?
After 1 week.
After 1 week. The petitioner in this petitioners in this petition challenged the order passed by the project director R&R Lower Circle Irrigation Project Palangi. He is the opposite party number
5, my lord.
5. in holding that since the land acquired percentage is 71.40, which is less than 75%, therefore, the entitlement of rupees 5 lakhs per head, as was sanctioned and paid to the petitioner, was as per the provisions contained in the second schedule of So Act 2013. And therefore, no further action is required to be taken. The London Council for the petitioner, relying upon the decision of this court or Supreme Court, the decision that
reported in 2000 OLR SC.
the Supreme Court decision, High Court
Supreme Court decision.
of the
Reported in 2017 one OLR.
Honorable Supreme Court in case reported in 2017
one OLR.
OLR Orissa Law
SC.
Reviews bracket SC page 774 submitted that the petitioners are entitled to get what is the decision says more compensation,
More compensation.
being the affected family members under the Lower Saktel Valangir. However, he seeks for an adjournment to verify whether the factual scenario of the present case is similar in the aforesaid so supra, and praise for an adjournment put of this matter in the week commencing from 4 तारीख रखू छु but week ही 4th of November 2020.
Item 5.
May I please, Lord? Lordship, what happened, my lord?
Just yes.
Lordship, what happened? On last occasion, manager East Coast Railway, they have already received the copy, my lord. According to my lordship's direction, my lord.
No, the order that was passed on 1/10/2024 reads like this, that Mr. Padhi submitted that he has not received a copy of the writ petition, and you said that you will supply a copy to Mr. Padhi. So what is your submission now?
My lord, I have already submitted
You have
copy,
already
my lord.
supplied a copy to Mr.
My lord,
Padhi.
We have received the copy with short for instruction, but we have not received any instruction in this regard. According to his Annexure 3, Para 5, Lordship may see.
Annexure 3, just a minute.
Annexure 3, page 10.
Annexure 3, no, Annexure 3, 2 is the page 10, that is ROR. 3 is
ROR.
East Coast Railway.
In our case, in our brief, it is Annexure 6.
But it was marked Annexure 3 and page 10 was written. Anyhow, my lord, this is letter dated 1/12/2023.
That is okay. That is actually Annexure 3. 3 Annexure 3 habo.
Aaya.
6 is
6 is bhul hai.
1, 2, 3.
The paragraph 5, it was written that, just I am reading, my lord, that as per the railway alignment after acquisition of 0.370 decimal land of plot number such and such, balance area of 35 decimal actually remains on one side and not on both sides of railway line as claimed by you. Moreover, there is no specific provision for under Land Acquisition Act to acquire and pay compensation for the balance land which is not acquisition of the land. He is saying that because the balance land is there, it is required to be acquired and compensation.
But is there any provision? Suppose you acquired a piece of land and the other part of the land which is there, it becomes useless. He cannot use it for any purpose whatsoever.
But,
because of that.
one
So,
case, I'm in the other side. I
Mhm.
also filed the same. I could not succeed. In Indian Oil Corporation, acquire a particular piece of land. Other side is not unutilized by the person
Right,
party. But this we have lost the case. We cannot succeed.
no, perhaps that is
Yeah,
the
I mean the
that is the prayer.
his
Because the other side he cannot use it for any purpose whatsoever.
exactly. It's
My
got
lord.
to the judicial intervention, my lord. It is a question of law. So we
That
should
is
use it.
exactly
My
the
lord.
case.
My lord.
All right, you take when will
Yes, yes, I'll take it.
Pari kebe ରଖିବା କୁହନ୍ତୁ
2 weeks after, my lord.
2 weeks after. All right. The Mr. Pari, P.K. Pari, Deputy Solicitor General of India, submitted that as per the 10/2024, he has already received a copy of the writ petition from the Land Council for the petitioner and sought for instruction, which is yet to be received, and the matter may be taken up after 2 weeks put of this matter in the week commencing from 11th November, Mr. Pari.
Yes, my lord. Yes.
Oh.
Obliging.
The name of the form to be reflected in the policy.
Item 6.
May I please, your lordship? My lord, the petitioner's land has been utilized by the opposite party for construction of public road and then toilet and installation of electric pole, your lordship, without acquiring the property. I have made number of representation. Fortunately, in one representation, the my lord, it is in page 29, 16th of October 2023.
No, you have submitted a representation.
I have submitted representation.
So when the last representation?
Last representation has been taken into consideration by the Under Secretary of the Government and he has written letter to your lordship may kindly turn to 51. So that is only to be considered.
Sir,
Yes, so but no, so far they have not given any. The collector is to be given direction to consider that.
Yes,
Yes, of course.
in inviting the reference to the subject, I am directed to enclose here is a copy of the representation dated so-and-so of Srimati Pramila Deo regarding utilization of her land by Puri Municipal Authority without acquisition and request you to inquire into the matter and take appropriate steps as per law so-and-so. So this was made on 4/12/2023. It was addressed to collector. So no steps are.
No.
All right. Therefore, this petition has been filed with by petitioner so-and-so with a prayer of so-and-so. The Land Council for the petitioner to the attention of this court to the order dated 4/12/2023 passed by the uh, Under Secretary to Government and it has been addressed to the collector and district magistrate, that is opposite party number 2 on the petitioner dated 16/10/2023. The Land Council for the petitioner submitted that as per the safe order, though the representation has been forwarded to the collector, opposite party number so and so, for making necessary inquiry into the uh, averments made in the representation regarding utilization of the land of the petitioner by Puri Municipal Authority without acquisition and to take appropriate action as per law for redressal of her grievance. But the opposite party number so and so, this is the collector, has not passed any order and therefore appropriate direction may be issued in that respect. Land Council for the state has no objection submission made in view of the limited nature of grievance of the petitioners. The opposite party number one is directed to take follow-up action as per the later dated so under Annexure 8 and pass necessary order within a period of so and so, and communicate the order within a period of 15 days of the taking the decision and so on. So it is made clear that we have not expressed any opinion on the representation that it's once stated to have been made by the petitioner. Yes.
Obliged, Your Lordship.
Item 7.
Item 7, similar petition your lordship had disposed of before vacation. Lordship had given me liberty since the file is pending before the executing court. You moved it over there.
Similar order to be
Changes
passed.
and I have made necessary corrections.
Okay, the correction will be disposed of, yes.
One
Item 8.
item 7.
There are other matters connected.
No. Item 7, I have filed the certified copy by the annexure 1. I feel that when be returned with substituting by the Xerox copy. That is the certified copy of the LA case.
So you want to take back the certified copy, substituting it by a photocopy.
What you will do with this?
You have a MCL and you will take back.
LA case ରୁ ପାଇବା ମୁସ୍କିଲ ପୁଣି ଆଉଥରେ ଆସିଲେ ମୋତେ ପୁଣି ଛଡ଼ା ଦରକାର।
All right. IA numbers from file କରିଛନ୍ତି
ନା ନା I file sorry
IA file କରନ୍ତୁ କିଛି ଆଚ୍ଛା କଥା ସେଟା ଆଉ ଗୋଟେ ଫାଇଲ କରନ୍ତୁ dispose of ହେଇଯାଇଥିବ ସେତେବେଳେ ନେଇ yes next.
Item 8.
May I please, Your Lordship? Well, here is instance case. I have challenged the order filed by the Lord Sub-Collector Cuttack under Annexure 8 Miller, wherein the Lord Sub-Collector has directed me to file civil suit.
Yes.
Instead of here is a case, Miller. Your Lordship may kindly come to under Annexure 1 is my ROR, stood recorded in my name, Miller. And Your Lordship may kindly come to a running case wherein the property stood recorded in the Rakhit Khata, Khata number 5669. That is a government land, Miller. And the opposite pet number 6, he has encroached upon the government land way back in the year 1981, Miller. And thereafter, in 83, he has been evicted by due process of law under annexure. And subsequently, it is found that he is an employee under a Agro Industries Limited, and he has retired from service. And on the he has made an application.
No, you come to the order. We have not.
Yes, Miller. So let me kindly come to
the order, impugned order. 73.
70,
passed by the sub-collector.
74, Miller. Running case, yes, Miller.
Come to 73. Yes.
73, Miller.
Yes.
73, Miller. The appellant has filed this appeal being aggrieved by the order dated 10/8/2023, passed by Tahsildar Salipur in revenue miscase number so and so, arising out of WPC number so and so, and lease appeal number 3 of 20. Hired an advocate for the appellant and respondent number 3 and 4, also hired the law and government leader for the respondent number 1. Gone through the memorandum of appeal, all the relevant documents filed by the appellant, also gone through the written submissions filed by the respondent number 3. It is revealed that the appellants have prayed for passing of the order dated 10/8/2023, passed by the Lord Tahsildar Salipur, and further prayed to cancel the illegal lease settlement dated 16/10/1985 in lease case number 82 of 84 in connection with the government land under Rakhit Khata number 569, plot number 189, acres 200 mills, Kisam Patita, under Mauja Champati, and remove all illegal iron wire fences, demolish the structure to resume the government land. The opposite part number 3, namely Vijay Kumar Swain, son of Vrindavan Swain of village Sampati, initially unauthorizedly encroached the government land under Rakhit Khata number 569, plot number 189, forcibly in the year 1983, and subsequently applied for permanent lease for agricultural purposes projecting himself as a landless person, and the decision Salepur had also settled and granted permanent lease in favor of operational 3 under Section 7(2) of the OPLA Act 1972. On the basis of the order passed in WPC number so and so, the Tahsildar Salipur initiated a miscase bearing number 9 of 2023 and also disposed of the matter with certain genuine observation on dated 10/8/2023 within the limit given by the Honorable High Court. Honorable High Court order. So, and that is the operating part of the order. In the backdrops, this court has gone through all the relevant documents available in the LCR, came to the conclusion that there has been no irregularities committed by the Tahsildar Salipur while passing the order dated 10/8/2023 in a revenue miscase number so and so and lease appeal number 3 of 2021. Hence, the order of the Tahsildar Salipur is upheld, but the appellants argues that myself similar. The Tahsildar has non-examined the case prudently and whimsically passed the order without examining the documents. In addition to that, the appellants further argues that the respondent number 3 is not a landless person and he has managed to acquire the lease in a fraudulent manner. Hence, if any party is aggrieved by the order, he is advised to take shelter before the competent civil court as the case is exclusively in civil in nature.
So
My
the,
submission would
the lease was granted in favor of that opposite party number 3, Vijay, in the year 1983.
81, 85.
ଲେଖା ହେଇଛି ଆମେ ଯାହା 83 ସେ acquire କଲା ତାପରେ ତାକୁ lease ଦିଆଯାଇଛି 85 ରେ. And you are challenging that order after 40 years almost.
Yes.
In 2023. So what is the time stipulated to challenge in the appeal?
Your Lordship may kindly come to Section 17 of the Limitation Act.
We'll come to Limitation Act. But what are the factual aspects involved here?
Yes,
whether it can be adjudicated in the writ petition? So many factual aspects are there.
Yes,
first, the lease was granted.
Yes.
Your claim is that the lease is to be cancelled.
As because
it is taken on fraud.
Yes.
So ground of fraud is there.
Yes.
Whether in the writ jurisdiction can be adjudicated.
Yes, and that is why.
So many aspects are there which need to be adjudicated only in the civil side. That is how rightly this court has passed.
I am just clarifying your Lordship.
What is your locus standi? How you are challenging that?
Yes,
how you are challenging that lease to be cancelled?
Yes, because concealing his service.
No, who are you?
Yes.
Who are you? Let him do whatever.
Yes,
who are you?
I am affected when in my land miller, private land, he has encroached upon this land, thereafter constructed a building.
And he will come in read.
No, Miller.
He is a private person.
He is.
You are a private person.
That is why prudently I have award his name as styling his opposite 6 and 7 because natural justice.
You cannot come in guise. Come in guise. Your direct claim is against opposite party number 5.
And direct, yes, Miller.
Yes.
As because it is a government land, Miller, and it is a statutory bar under Section 7.
The lease was granted to him. That was his different land. That was not your land. That's a government land.
Yes.
So if he has encroached a part of your land, so the remedy is available elsewhere. It's not in a writ petition.
No, Miller. Your Lordship, may I just say that is why Section 7(b) of this OGLS Act says no civil suit can lie.
No, you are not under OGLS, sir. You are not under OGLS. You are not under OGLS. Why you are bringing OGLS here?
OGLS that has been granted in favor of that man. So we are not concerned with that. If he has while occupying that government land by way of a valid lease, if he has acquired, as you say, acquired a part
In
of
front
your
of
land.
my house, Miller, he has
Whatever it
constructed
may
a
be.
building.
So,
That is, my passage is blocked.
so the OGLS is to be of that man, not by you. If anything goes wrong, he is to apply this OGLS. You have no remedy under OGLS.
My submission would be, when the Tahsildar has committed irregularity, manifest irregularities, while granting 7-2, yes, 7-2, I am challenging 7-2, in which
under writ. Under writ.
Yes, Miller.
You have a fundamental.
My
fundamental
right has been affected.
Violation of fundamental right.
Yes.
What is that?
If in front of your house somebody has blocked a road, then there are other method remedy available in the CRPC now in the present act to remove that. So it's not that
Your Lordship may kindly have a glance to Annexure 9, my lord. I have annexed. This honorable court has rendered a judgment under Annexure 1 and 9, my lord. Running page 17, your Lordship may kindly come to. And the Placid
right of easement.
Natural, natural right has been affected. Yes. Your Lordship may.
No.
And this honorable court has been directed that natural right, just Placid, I am para 14. Natural right and right of his distinction. Approach to public road. Owner of the land has a right to approach from every point of his land. He can enforce such right in a court of law. Availability of any space which could be used as an alternative passage could be denied him of his said right, Miller.
So that was a passed in a second appeal in which the suit was there, then appeal preferred, then second appeal that observation was made. So you have, that is why he has said that you go to the civil court.
Just your Lordship may kindly come to the Annexure 8. I am taking your Lordship, Miller, how the sub-collector taking a different, taking a contrary view. In one hand, he has said the lease has been set aside. That is deemed to have cancelled. Under Annexure 6, Miller, your Lordship may kindly come to Annexure 6.
The order of the Tahsildar is upheld.
Subsequently, that is a second round of litigation appeal I have preferred. But in first enforcement appeal, I have preferred under Annexure 50, Lord, 6, Miller, running page 59, Miller, your Lordship may ordering person, Miller, delay in filing both the appeals are condoned under Section 5 of the Limitation Act. Your Lordship may running page 50, 59, bottom of this. In the first appeal, enforcement appeal I have preferred, wherein it has been the same sub-collector has been condoned the delay and narrating all my under your Lordship may second running page 60, Miller. Your Lordship may kindly come to peruse all on the photography of LCRs in lease case number 82 of 84 and revenue lease case number 10 of 21, gone through the appeal memos, note of argument, copies of the documents available in the record. In both the appeals, the land dispute relating to
so it's all right. Delay has been condoned.
Delay has been condoned and set aside. Running page 61, 61 million.
That is referred to the Tahsildar.
Tahsildar. Thereafter, the Tahsildar and again directed to be recorded in the name of 6 and 7. I have preferred second appeal. Again, thereafter, the land sub-collector says that that is only civil remedy can be available by the
petitioner in person has filed this.
I have already filed a revision, Miller, under Section 7A3 of the before the ADM Kotak, Miller, and that is pending.
Challenging the order dated so and so passed by the sub-collector Cuttack, Sadar Cuttack in Miss Appeal number 41 of 2020. After arguing for some time, the petitioner submitted that a revision application has already been preferred, challenging the aforesaid appellate court order, the order passed in the appellate court. Since the petitioner has already availed the alternative remedy available to him, we are not inclined to entertain this writ petition. It is accordingly dismissed.
My predicament is, my lord.
Yes, next.
In the meantime, my lord, the opposite party number
Otherwise,
6 and
we'll
7
go, we'll go and in merit I will reject it. Yes, next.
Item 9.
Yes, 9.
Yesterday, two matters were there. My lord has
yesterday
it is a dispatch.
item 24 ଥିଲା ଗତକାଲି list.
ଗତକାଲି item number 24 ଆଉ ଗୋଟେ କେତେ number ଥିଲା?
My lord, I am pardon. 24 or 42.
24 ଆଉ 42 ରେ ଯୋଉ order pass ହେଇଥିଲା ତାକୁ ସେଇ type ର order pass
ଏଇଟା ଆଜି ଗୋଟିଏ 9 କେବଳ
9 ଆଉ ଗୋଟେ ଅଛି 37.
130
No, my lord,
Only
pardon, 37.
only 30.
9 ଆଉ 37.
9 ଆଉ 37 ରେ same order କରିବେ କାଲିର ଯୋଉଟା 24 ଆଉ 42 ରେ ଯୋଉ order ହେଇଥିଲା
WBC 30 by 24.
ଆଉ 25 28 3/24.
item number 24 ତ କହିଲେ ଆଉ
ହଁ 24 ଆଉ 42
WPC
25460.
25460 of
24.
2024 that is item number 24 ଦେଖିଲେ
ଆଉ 42 ବି 25803 3/24. My lord, I am pardon, 37 same.
yes
9 ଆଉ 37. 9 ଆଉ 37.
37 ପୁରା ହେଲା
ଆଜ୍ଞା, okay.
ହଁ ମାନେ ଆଉଥରେ ସିଓର କରିବାକୁ ଚାହୁଁଛନ୍ତି
ନାଇଁ
ଏଥର କଣ ପାଇଁ yes
10.
ହେଲା
Sir, only prayer for consideration of OTS application.
କଣ 13 ଟୁ ନୋଟିସ ହେଲା ଆପଣ 13(3)A କୁ ଯିବେ କଣ ହେଲା ଆପଣ
I filed my lord OTS. Only prayer my lord OTS.
ଆପଣ କଣ ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି କଣ
13 to notice of the surface act my lord.
13 ଟୁ ନୋଟିସ କେବେ ହେଲା
My lord, 12/9/24.
come to that 13 to notice
My lord, that annex
there is
1.
one opportunity you come to the last portion
Yes, my lord. My lord,
you are therefore advised to comply the demand under this notice and to take further action under so and so act ତାପରେ ଆପଣ representation ଦେଲେ
Yes, my lord.
କେବେ କାହିଁ
My lord, that is at annexer 3 my lord, page 26 my lord. 25 ନରେ ଦେଲି my lord.
କଣ ଲେଖିଲେ ତା ଦେହରେ
My lord, to consider my OTS and I have gone to make payment, but they are not receiving my payment also my lord.
ଆପଣ ସେ ଯୋଉ ପ୍ରୋଭିଜନ ଅଛି ତାକୁ ସେଇ ଅନୁଯାୟୀ ଦେବେ ନା ଏଇ ଦେଖି ସେ ପାଠ ପଢ 13 ଟୁ ନୋଟିସ ଟା ଗୋଟେ ଲିମିଟେଡ ଇଏରେ ଆପଣ ରିପ୍ରେଜେଣ୍ଟେସନ ଦେଇପାରିବେ ଯେ ଆପଣ ଯୋଉ ଡିମାଣ୍ଡ ଟା କରିଛନ୍ତି ଏଇଟା ଇଲିଗାଲ come to have you got that book with you 13(3)A
No, my lord.
ବହିଟା ବି ଆଣିବେନି
Sorry.
13(2)ରେ ଆପଣଙ୍କର ଡିମାଣ୍ଡ ସେମାନେ କଲେ ତାପରେ 13(3)A କହୁଛି if on receipt of the notice under subsection 2 the borrower any representation or raises any objection the secured creditor shall consider such representation or objection and if the secured creditor comes to the conclusion that such representation or objection is not acceptable or tenable he shall communicate on the receipt of such representation or objection the reasons for non-acceptance of the representation or objection ଆପଣ ଯୋଉ one time settlement ର ଯୋଉ ଦେଲେ ତାଙ୍କୁ application on 25/9/2024 have you received any communication from
Till now.
you just want it to be disposed
Yes,
of
yes, my lord.
the petitioners so and so have filed this petition with a prayer to quash the notice dated 12/9/2024 issued by the opposite parties under section 13(2) of the SurfSI Act. Inter alia with a prayer for a direction to the opposite party to consider the OTS application of the petitioners dated 25/9/2024 under annexure 3. The Land Council for the petitioner submits that when the opposite party raised a demand କେତେ ଟଙ୍କା ଡିମାଣ୍ଡ କରିଥିଲେ ରେଜ୍ କରିଥିଲେ
let's say demand କରିଛନ୍ତି
10 lakh 69
10 lakhs
yes my lord
paragraph number 7 ने देखिए
Seven.
amount लिखा है
10,69,167
as on 10/9/2024
Yes,
with interest he filed an application under OTS on 25/9/2020 before the branch manager so and so लिखा है by post and no communication has been received from the branch manager. That is the opposite party number 1. Considering the submission made by the Land Council for the petition, if any such application is pending with so and so, and it has not yet been considered, the same may be considered in accordance with law. We have expressing no opinion on the merits of this one. This was and communicated. Okay.
Item 11.
The matter is relating to GSL matter, my lord. The representation is pending, my lord. I mean, I am item 11, 12, 13. Again.
Sabu annexure 3.
Again.
11, 12, 13, 14 and
Again. 13.
এই চারটা
Again.
আউটে আছে পুরো নাই
11, 12, 13, 14.
My lord.
Sir, number like this and this goes.
Item 15.
Please, your lordship, on behalf of A. Patnaik, I am next sir 9 claim application for claim commissioner is pending, my lord. Maybe dispose of it.
E-auction cell.
E-auction hello also. We are not at this. E-auction cell notice ହେଇଗଲାଣି ତ? That is annexure କେତେ?
Annexure 9.
No, annexure 3. 15.
Annexure 9. 58/23.
Just
Claim commissioner.
556.
My
556 here.
No, later your government.
556 ହେଲା ମହିମା ନାୟକ, right?
My lord.
ପ୍ରେୟାର ଆପଣଙ୍କର ଆସିଲା
Claim commission. Claim commission is pending as
that commission now functioning because that period, so we cannot pass any order.
My lord. Put up a move.
It is submitted by the Land Council for the prayer in this requisition is for a direction to so and so. However, it is submitted by the Land Council for the that the term of the claim commission has not been extended after 31st October 2024, and judgment in that connection has been reserved by the Honorable Supreme Court, and the matter may be taken off sometime after. Put up this matter when yes.
Item 16.
Item 16, my lord. Petitioner challenges the auction notice, my lord. Annexure 3. Copy.
So auction notice, go to the
Option
appropriate.
Annex 3. Date is fixed under 28/10/24, my lord.
Auction sale notice, alternative remedy available, disposed of, yes. You are,
I am for the bank.
bank for, Sunil Kumar Swine.
Yes, ma'am.
I solved the copy, my lord.
It's all right. Alternative remedy available, disposed of. Next,
Item 17.
Mr. Misra. Yes.
My land has been acquired,
Presentation pending by Annexure 4,
my lord.
when it was filed on 21/6/24.
24.
You have not received any communication.
No communication.
Annexure 4 is to be disposed of.
All right.
Mr. Saugat Das. Saugat, one of the next.
Item 19.
My pleasure, your lords.
Yes.
The petition of this Honorable Court challenge the order of the Central Administrative Tribunal, my lord.
Yes.
In the batch matter, your lordship already issued notices, and the matter is posted to 28.
Acha. In similar matter, notice has been issued. Similar matters, that is WCC number 151. Similar matter, notice has been issued. And notice for the
Instruction by okay. Can we dispose of at the time of admission?
Senior panel counsel has been asked to obtain specific instruction.
କେତେ କେତେ
19.
Mr. Pari, ତା ଦେହରେ ସେ Mr. K.C. କର appear କରୁଥିଲେ
ଆଜ୍ଞା
Union of India,
ଆଜ୍ଞା
senior panel counsel, ତା ଦେହରେ instruction ନବାକୁ ସେ ଇ କରିଥିଲେ, ଏ similar matter ସେଇ order ହିଁ challenge ହେଇଛି।
yes yes ଜଳଶକ୍ତିର ବିଭିନ୍ନ କ୍ରିଟିସିଜନ ପାଇଲି।
So, out of this matter, along with WPC number so and so, in the week commencing from 28/10/2024. ଏଇଟା ଯୋଉ ଡେଟ୍ ଅଛି ସେଇ ଡେଟ୍ ରେ ରଖିଦଉ।
ଆଜ୍ଞା ଆଜ୍ଞା 2010
ହଁ
Mail.
ଡାଇରେକ୍ଟ କେସ୍ ଗୁଡାକ ସବୁ ଆଗରୁ ଟେକଅପ୍ ହେଇଯାଇ ତ 28/10 କୁ ଅଛି।
in this case along with me Mr. Kashyap is appearing
ହଁ ନାଁଟା ଲେଖିଦିଅ। କାହା ନାଁ ଲେଖା ହବ କୁହନ୍ତୁ ଆପଣଙ୍କ ନାଁ?
along with me Mr. S.S. Kashyap Satya Sindhu Kashyap
ଦେଖିବେ ସତ୍ୟ ସିଂ କାଶ୍ୟପ। ସେଣ୍ଟ୍ରାଲ ଗଭର୍ଣ୍ଣମେଣ୍ଟ କାଉନସିଲ ତ ସେଣ୍ଟ୍ରାଲ।
ah CGC Mr. Kashyap is CGC
ନେକ୍ସଟ
Item 20.
Item 20, lordship, pray for next week.
But what will happen here has already been taken. Why to linger it? ITCO has already taken your position. See Annexure 7. That is your document. Wherein the divisional head ITCO reported that the OP has already been evicted
Symbolic
and requested to close the opposite party case. Yes.
Lordship, pray for next week. That's my learned symbol.
the Grand Council for the petition of 6 permanent adjournment could have this matter on such as. Next.
Item 21.
May I please in full prayer for disposal of representation, that is Annexure 10. Yesterday, your lordship, that is item number 36.
I would pass it to your order.
I खाली representation disposal.
Kali thila.
Item 36.
Item 36 जो order pass it to fair.
Aji केतुटा एटा?
Annexure it will change. There Annexure 11, here Annexure 10. And in respect of serial number 31.
No, 21.
21 to your lordship, 21, 22.
22
My lord.
Aur hi ache bata?
23. And also 26.
26.
27. 28. All these cases are Annexure 10.
All right.
All right. But
say देखिए item number 36 रे खाली annexure change होगा
31,
31 annexure 9 and 35 annexure 9.
31, 35, annexure 9.
Annexure 9.
31 item number 36 program 35 and out of the
Ajiro eta.
तो खाली 36 सहित
ଆଜ୍ଞା।
सोडा दिया आज ये रहला 31 और 36 नहीं कि
31
31 और 35.
33 ଆଜ୍ଞା point।
आपको
କାଲି ଯୋଉ ଥିଲା annexure 11 ଏଗୁଡା
मैं ठीक है
obliged।
21 22 23 then 26 27 28 then 31 and ठीक था okay next
Item 24.
yes Mr. Nandi
Yes.
Here the petitions are loaning and also guarantor. 6. Interference of this Honorable to allow them to deposit entire auction amount, to deposit the and to return back their.
Lordship, I am for the bank. I am instructed to appear. In this matter, sale certificate is already issued and the property is already handed over to the auction procedure.
But
So the
of
writ
now
petition may
matters-
be infructuous, Your Lordship.
no, my lord. I am
It's my
challenging
word,
the process of e-auction, my lord.
so have you gone through that decision in
Yes, my lord.
Kapna Motors yes
Kindly have a glance to the sale certificate, Your Lordship.
He has to certificate mate ଗୋଟେ copy ଦିଅନ୍ତୁ।
First, 100%.
ମୁଁ
Writ
ଆପଣଙ୍କୁ
petition copy.
read
I
petition
will-
ଦେବି। ଦଉଛି ମୁଁ ଅଛି।
ଦେବି, ଗୋଟେ copy ଅଛି ତ,
the
ଦେବି।
petitioner has challenged the such and such Mr. Sunil Kumar Swine has entered appearance for the opposite party bank and he has filed certificate issued in favor of one Ranjita Giri, na?
Yes, Your Lordship.
Ranjita Giri. The copy is taken on record in view of the decision of the Honorable Supreme Court in case of so Bapna Motors.
No, my lord, I am just a minute.
Yes, yes.
I am challenging the process of e-auction.
Whatever it may be, it cannot be entertained because of this situation. Just go through that decision. We are disposing of. Yes.
But I can challenge it.
The moment even say auction
auction is
notice is issued, matter ends there. Cannot.
But
High Court should
thereafter,
High Court should not touch it. That is the decision of the Honorable CGI. Recent decision, Bapna Motors case. So we are disposing of in that light.
but
Very strictly, they have stated, don't entertain.
then where we will go, my
So
lord?
that please read that decision. That is the answer is there. Yes. Next.
Item 25.
Then he
Yes.
should.
Item 25.
ମୁଁ ଦେଇ ଦଉଛି ଏଇଟା।
Please, Your Lordship. The order of the tribunal has been assumed
Yeah.
that order dated 3/7/2024 under annexure 1, my lord.
Yes. What order has been challenged?
My lord,
I have been instructed to appear in this case. Please instructing kindly supply for.
Give it copy.
I'll provide.
Please give your name so that
Nirmal Ranjan Raut.
no, you will appear for whom? This opposite party number 1.
Only open number.
Only open.
No, there are-
Private party, my lord. Yes.
Oh, private.
because there are. You please come to the writ petition. There are actually 5 opposite parties. One is the opposite party. There are also 4 pro forma opposite
Yes,
parties.
And I am for what?
That is
One.
exactly what I'm
That is
telling.
what.
All right. So and so submits that he has instruction to appear for opposite party Gopal Chandran and will file the wakalatnama. Kebe file karibe?
Tomorrow.
By tomorrow. Let the land and council for the petitioner serve a copy of the writ petitions on the land and council for the opposite party by during course of the day, because you file or tomorrow.
By tomorrow.
By tomorrow. List this matter next week.
Yes.
List this matter next week, indicating the name of so and so in the court. Yes.
Lordship, that decision your lordship has referred that.
That paragraph will be quoted there. That entire paragraph, what has been observed, paragraph number 110.3 of Bopna Motors case. Yes.
Item 29.
Your Lordships. Your Lordships may come to straight away page number 29, which was the order of the Tahsildar earlier in the year 2012, 13, 39/2013, Annexure 5. So Lordships would see the last two paragraphs. Page 29.
Annexure 8 you want to?
Yes, my lord.
What is that order?
The prayer to grant me the lease for...
come to that order. Come to that order.
Yes, ma'am.
Annexure 8.
Annexure 8, page 34.
Yeah.
The last two, my lord, the grounds for rejection has been given.
What was your prayer?
Yeah. If your lordships, that's why, my lord, I said your lordships may come to Annexure 5, page 29. Where because I was to set up a petrol pump, and some adjacent land was required for that further lease to be leased out to me by the government, so that I set up for the staff quarters and all the amenities. So for that purpose, I applied, and that was recommended also. Your lordships may see page 29.
29.
By the same authority, by the Tahsildar himself.
Okay, that was submitted to the collector. Yes.
And then the next page, your lordships may see what was the sub-collector's order.
Next page. Okay.
I'll just read out, my lord, from mid of that second
page
paragraph,
30.
page 30.
Yeah.
If your lordships would say, according to the term and condition, mid of the paragraph, which is the longer paragraph, second paragraph.
Second paragraph, middle.
Yes, according to the terms and condition of later dated Bharat Petroleum Limited, the applicant is required to arrange land for development of retail outlet within a period of 2 months from the date of issue of the letter, failing which the offer is liable to be withdrawn. Further, the benchmark valuation of the land has been obtained from DSR Jharsuguda on dated so and so. The recent benchmark valuation is to be obtained and calculated for the amount of premium to be paid by the applicant. So that was all which was directed, that the current benchmark valuation has to be done. Now what has been done, my lord, they sat on it, then I approached before your lordships, and at Annexure 6, a simple direction was issued that you dispose of this issue. Then your lordships, the subsequent at Annexure 7, page 33, which is in 2014. That was almost after a year's time. They said, Lord, initially the proclamation...
order was passed on
38/23. Yes, my lord, the last order, Annexure 8, is following that. Annexure 7 was, there was a public notice was given earlier before the lease was recommended. Again, somebody or some persons also complained after that, subsequent, which was taken into consideration by the Tahsildar. And your lordships may see read the last two paragraphs. However, a petition from the villagers of Kumudpalli has been received regarding encroachment of the applied land by the applicant herself. Because that land I was to develop for the purpose of the petrol pump only. Because that period lot I read out was for a period of 2 years. I have to get the permission and start the installation because it's a time-bound program. To verify the fact, RI Jharsuguda has directed to field inquiry to do field inquiry and report. As per report from RI Jharsuguda, dated so and so, the petitioner herself has enclosed a part of the applied land without any sanction from company, which is illegal and attracts provisions of OPLE Act. As per the provisions of OGLS Acts and Rules, the land proposed to lease should be free from all encumbrances. So that is my position. They say that I should first leave it and then the permission, if at all, put up the case record after making the land free, which has been left out from all encumbrances.
It's all right. So
yes,
thereafter the order was passed by this court and
This
it was directed to dispose of in that lease order. What is the illegality? That Annexure 8.
Annexure 8, my lord, the land which has been shown, the two grounds. There's a high grade voltage substation is running on the south of the plot, which is beyond the area. Number one. Number two, the same encroachment which has been said about it is the same which has been constructed for the petrol pump. And on the same ground, they have now rejected.
So, is there not any alternative remedy available to
There's
you
an
to challenge the order?
There's an appeal, my lord. I admit to that
go and
position.
The London Council for the petition of fairly submits that against the impugned order by the Annexure 8 passed by the Tahsildar Jharsuguda, there is appeal provision.
But the only problem is there's a
Given the
1 month period
apply
for the appeal that may be.
prefer the appeal, and the period for preferring the appeal is already over, and in case an application is filed for condoning the delay, the same shall be considered in accordance with law. Without expressing any opinion on the merits of the case, if any appeal is filed before the appellate authority with an application for condonation of delay, challenging the order dated so and so by the annexure, the same shall be considered in accordance with law. Dispose of yes, next.
Item 30.
I may please, my lords. Lordships, the petitioners are in different district judiciary. One is from Baleswar and one is from Balangir. They are here before my lords for fixation of their fixation of their pay scale with the at par with revenue inspectors. Lordship, when the salaried posts were created, the entry level qualification for them was
You submitted a representation
yes
for the registered administration Odisha High Court Lekaiji.
my lord. There was a
petition.
that case, lordship, there was a direction for a refusal, and the order is at Annexure 17, my lord.
17.
Again, last Annexure 17, page 83. Again.
With reference to this order, I am directed to say that the court, after careful consideration of the matter, have been pleased to decide that after the observation in so and so, the demands put forth by the representation so and so involved in the affairs of
matter to be taken up by the government only.
Have been considered and disposed of our things. So, what order was passed in that WPC number so and so? Have you that order?
And that is at Annexure 15, my lord.
Annexure 15.
73.
So what is the operative part of that order?
Operative part is at page para 21.
As agreed by the so and so, the petition stand disposed of permitting the petitioner to approach the authority by making phrase representation within a period of 15 days, hence highlighting the grievance as has been made in the petition, so that the authority can consider the same and pass appropriate order in accordance with law, considering the nature of our discharge by the petitioner, and so also into the report furnished by the SETI Commission as well as the judgment rendered by the apex court. So what happened thereafter?
After this, the registrar has simply said that just because another writ petition is pending, we will not pass any order in this.
Another has been disposed of, that also that has there. If you read that annex, page 83,
my lord,
stated that as per the observation in so and so case that you have annexed as annexure 15, right?
My lord.
So the demands put forth by the representation so and so involving essay have been considered and disposed of, awaiting the final result of so on. ତେଣୁ ଏ ମ୍ୟାଟରଟା କଣ ହେଲା ଯୋଉ
ସେ
6995
pending ଅଛି ଆଜ୍ଞା, pending ଅଛି, ଖାଲି notice ହେଇଛି, nothing else. From the date of inception just ହେଇଛି ବାସ୍
2020 ମ୍ୟାଟର
ଆଜ୍ଞା.
pleading complete ହେଇନି?
Not my matter, I have no instruction. I just have seen the order that just notice has been issued in this case.
Similar matter is pending.
No.
We'll tag this matter to that writ petition.
This is also my lord's assignment. WPC 6995 of 2020.
We'll
My lord's assignment.
put up this matter along with, so that we'll see if the pleading is complete or not in that. Put up this matter along with WPC number so and so next week. Hello?
Grateful.
Item 32.
32, 33 has gone. Adjourned.
Item 36. Item 34.
The petitioner is the recorded, the government officer acquisition proceeding was going on, but this plot has not been incorporated in the list law. Subsequently, the petitioner found that the plot they have been include the petitioner's plot and making construction over the plot law. Despite that, to that effect, I also made grievance before the authorized.
Your representations is pending.
Yes, that and that was also the proceeding was initiated in acquisition case number 12.
Right, officers wants to pay. So this annexure 3 series is to be disposed of.
Aye.
All right. Annexure 3 series to be disposed of. All right.
Item 36.
Yes, ma'am. Ma'am, please, ma'am. Susila Beva, the lessee in 1983 sold the land to Vijay Chandra Patnaik, from whom I purchased the said suit land in 6.
Which order you are challenging?
My lord, the order of the ASO. Similar, same order. It has been in annex of 4. I have attached the page number 25-26. That my adjacent land, they have honorable court has ordered to quash the order of ASO. I am challenging that ASO order, my lord.
Direction is issued to the ASO now to proceed to the record the name of the petition. Words on. Acha. Narottam Rath case, sir. Land of Yes, Mr. Misra. The ASO जो order टा pass करिसेंती सेटाକୁ से नरोत्तम रथ केस रे वास ହେଇଛି ଏବଂ direction ଏଗୁଡାକ ହେଇଛି. Direction is issued to the ASO to now proceed to record the name of the petitioner concerning the election in her name, where the line in question stands recorded in the final swan, so in the name of the entry shall be cancelled by virtue of this order, and ASO will proceed to record the name of the swan. So above direction shall be carried out with one. This is the direction. ଆପଣ examine କରିବେ କ'ଣ?
Kindly call it next.
Kindly examine. କାରଣ ସେ କୋଉ ground ରେ ସେଟା rejection ହେଇଛି କ'ଣ ହେଇଛି?
Adjacent plot. Same owner, same purchaser, same everything.
Land Council for submits that the present case is covered in view of the judgment passed by this court in case of Narottam Rath versus State of Odisha, reported in 2023, SCC Online, Odisha 153. Mr. Mishra and additional government advocate seeks for an adjournment till next week to examine the case reports. So also the judgment of this court passed in Norottam Rock.
This order, this court has
Let him examine what is there. The code of this matter only. We commencing from 28th October 2020. Yes.
Item 38.
I permitted to move this matter from the Rotha. On the Rotha, I permitted to move this matter. There is some delay. There is fact A, your also the IN number.
Who is the other side?
My friend is the 38. I'm appearing TPCODL, my lords.
How many opposite parties are there, or the respondents are there? You are appearing for all.
My lord, so far as TPCODL is concerned, opposite part respond number 1 to 4, my lord.
Aukki ochandi, aukki
No, my lord. I'll appear for opposite number 1 to 4.
That's all.
Yes.
So no, appear mane kona.
I have already appeared.
Are you interested to file any objection?
I will file an objection. That is my instruction.
2021 ମସିହାରେ ଆପଣ କେବେଠୁ appeal କଲେଣି? Why have you not filed the objection to that?
My lord, in fact, the nomenclature, the erstwhile SESU was there. TPCODL has been recently noticed.
What is your good name?
Lalit Kumar Maharana.
Mr. Lalit Kumar Maharana, when counsel appearing for the respondents number 1 to 4, submits that it intends to file objection to the interim application for condonation of the matter will be taken up a week after. Put of this matter in the week commencing from 4th November 2024. Objection, if any, is filed in the meantime, giving copy to the Land Council for the appellant. Yes.
Item 59.
May it please, my lords.
What is the CMAPL?
My lords, for restoration of the writ appeal number 222 of 2015, my lords.
Delay for.
My lord had on the last occasion issued notice for condonation of delay, my lords.
So what happened?
Who
are the opposite parties here?
The opposite parties are
single opposite party.
Single opposite party.
So it has been served that notice.
It has been served, my lords. Notice sufficient. In fact, Mr. Senior Counsel, Mr.
It is returned from sole with signature of one or with
Mahanti. Relation of the account. So CMAPL 647 of 2022. That is relation to IA number 330 of 20. This is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 23 days in filing the CMAPL. Notice was issued as per the order dated 29/8/2024, and it has been pointed out by the stamp reporter that AD, and it is there in the office note that the AD has written from the sole opposite party with signature of one Arpit Mahanti, relation to the event, and the address is mentioned as son. The notice is held sufficient non-appears for the opposite party after perusing the averments taken in the interim application for condonation of delay and hearing the Land Council for the petitioner. We are inclined to condone the delay in filing the CMAPL. Accordingly, delay is condoned. So CMAPL restore it.
My lord.
When it was dismissed.
My lord, it was dismissed on 6/9/22, my lords.
Okay, CMAPL is launching an application for restoration of writ appeal, that is WA number 222 of 2015.
May my lords also, my lords, submit that on 16/5/2016, my lords.
There was a stay order of the impugned judgment of the learned single judge. When the writ appeal was dismissed, automatically the stay order was also vacated along with it, which is why, my lord, the accompanying contempt application for.
No, it has to be listed and
My
then
lord. My lord.
after hearing the land counsel for the petitioner and going to the government.
That 39 CMPL, there are two IAS minors. One IA has not been served on me.
39?
Yes, minors. That these places are 39. Yes, yes. I am for the opposite party.
Which one?
Pratibha.
That is 331 of 2024 has not been served on me.
That is, my lord, only an application for
I must
dispensing
know
of certified. Dispensing of certified copy, which is not required. I have the certified copy.
Your colony, इटारे कहीं notice sufficient है लापरा.
CMFL.
Notice टा प्रतिभा महासामुद्राय को sufficient.
Same bill टा.
हाँ.
Same bill सर तो ताकर condemnation और delay.
Right. Delay तो सिर्फ में हम delay condemn कर देलु.
ये सर कर देले.
हाँ because.
Sir, बहुत ठीक है. Aspirant class में ये गला that is my objection to that will be there.
अच्छा आपनो ना ये करी दो appear करी दो ना डाले की दो तो कितने दिन उड़े delay की
23 days.
23 days.
वो ना अपडेट
Not update.
ये appearance memo दी सर ले.
I was there in the conducting lawyer. वो appearance जो वो दी.
Yes, तो separately it and notice होना CMAPL fine.
That CMAPL which content page. जोड़े notice है sir. Next page is contempt. There are two matters so far as this case is concerned. And as per the Honorable Chief Justice order, this has come along with that.
That is all right. We see that when the notice has been made sufficient, nobody appeared, and it is a delay of 23 days, we condone the delay. So if you want to file any objection, file your appearance memo, you can file. If you don't file, so obviously delay we have condoned, then we have to restore the writ appeal. And it will be hard ultimately.
Sir, I was late by 2 minutes because I was coming through that way.
No, there is nothing. You can take up this matter tomorrow.
Yes, minus matter keeps up.
I'm a kali kali ki rakhi do.
Tomorrow also I'm husband that too.
Tomorrow. With this matter. The order of practice is you I here is for condemnation.
Have you copied the answer?
Yes. Next.
Item 40.
It's going to be requested at the administrative level, so I want to
withdraw. Restore the.
I am the appointment.
Land Council for.
Yes, sir.
Bhavani Shankar Rai, Good Land Council, and Central Government Council is present. Yes. Please.
Item 41.
WPC 19451 to be listed along with it. Both the matters are identical. No, typographical error. In fact, your lordship has directed that the section 3 application which is
pending. Staff report जो हमारा billing assistant देखे जी order number
sorry man
21/8/2024 रे order the order found the order number 110/24 order का कहीं
110/24 on repeated call.
That actually order number budget कर ले दिया. Here you the office note wherein it has been mentioned that in the order dated 1/10/2024, the order number has been inadvertently mentioned as 01 in place of instead of 02. Let the order number 01 asked on 1/10/2024 be read as order number 0. Is account को कौन जाएगा? इसको जो देखा बना out of I account by modification is what?
Your lordship has considering the no post prayer directed, let the section 3 application be disposed of it in a stipulated. But when I approached the Lawrence Tahsildar, he informed in fact that is not the case number, that is the diary number. Even 90 we have received on
ଯାହା ଆପଣ ଲେଖିଥିବେ ଆପଣଙ୍କର ପ୍ରେୟାର ହିଁ ସେଇଆ ଥିଲା।
in fact it was sent through registered post. The diary number was also
ଆପଣଙ୍କର
given.
ପ୍ରେୟାରରେ ଲିଜ୍ ମିସକେସ୍ ଲେଖିଲେ ନା ନାହିଁ?
ହଁ।
ଆପଣ ଯଦି ଡାଇରୀ କେସ୍ ଲେଖିଥାନ୍ତେ ଆମେ ଡାଇରୀ କେସ୍ ଲେଖିଥାନ୍ତେ, ଆପଣ ଯାହା ଲେଖିଲେ ଆମେ
After
କଣ
opening the
ବର୍ତ୍ତମାନ ଚାହୁଁଛନ୍ତି ସେଟା ହଉଛି କରେକ୍ସନ କରିବା ପାଇଁ, ମଡିଫିକେସନ କରିବା ପାଇଁ।
yes.
ଲେଖିଦିଅନ୍ତୁ IN number so and so is an application for modification of the order dated 21/8/2023. The Land and Council for the petitioner submits. The petition was filed. For expeditious disposal of कौन सा डायरी केस नंबर
Diary case matter.
और कोड लिखछन डायरी केस नंबर
That annexure
आपन को आईएर लिखना है
I have mentioned my lord.
कोड लिखछन जी आ जगह सेटा इया लिखा जाउबे लीज मिसकेस जगह रे इया मेंशन होबे कोड
Annexure 1 बोली लिखिछु. Register lease miscase by annexure 1 and take off followed action. mo prayer re लिखिछु.
आमे ऑलरेडी गोटे मेंशन कर साइलनो लीज मिसकेस का नंबर टा दे साइलनो जदी आपण चाहुचंती जे लीज मिसकेस नंबर जगह रे डायरी कोन गोटा लिखिया पड़ो आपण कहबे जे एई जिंसडा मेंशन हो सेंती कोड लिखचंती तर टोटल नाही तो ता भीतर से पिटिशन कोड अछि आपण
I have stated paragraph 4. It has not been registered as a miscase.
कोई ठीक अछि जे रजिस्टर्ड है जे डायरी नंबर दिया है
Diary number दिया
से डायरी नंबर 793 dated 25/2/2022
आगे
so and so submits that for disposal of
That means it has not been taken as a
no man.
Then how can you
They
ask
said
for the
that
disposal?
since it's a government land
so the diary नै छै कि माने तापरे
तापरे आउ रेजिस्ट्री करि ना हबी
नै करना थी माने अपन कोन तार गुटे थिबो ना ये अपन डिफेक्ट थिबो कि कोन
ना डिफेक्ट ना in fact I have stated that the opposite party number 3 has directed that it's a government land so it section 3 application OGLS will not be registered.
ताले हमें यदि वर्तमान कहि दबा डिस्पोज ऑफ करन तो केमति
सेटा ता माने ऑटोमेटिकली सेटा इग्नोर हे जिवो से
Simply more prayer kochi that the annexure 1 be treated as a lead miscase and action be taken because this was received by the diary number given. It was received sent through registered post, not by hand also.
आपण भी जोटा फाइल करछन annexure 1 रे पूरा लिखि जंदी लीज मिसकेस आपण हाउ डू यू फाइल
in fact I have sent it through registered post manner. The diary number was I have received. Thereafter my client get confused. See, he took off the diary number as the lease miscase. And his consistent effort he press held no result. That's why he approached your lordship.
Confusing है जो you file a better application and out file कर दियंदु order
out IA file कर दो
IN you just file another application. Yes, IA number so answer is an application so you don't file any modified IA disclosure. Yes, next
item 42.
Yes, Mr.
Then IA your lordship may permit me to withdraw. So that
IA टा will problem is withdraw.
Lordship has disposed of the writ application by the order dated 18/9/2024. But while the order at page 2, the Lordship can see page 2, while reproducing the order passed in the earlier writ application, the Rakhit Khata number, page 2, first line, Rakhit Khata number 483. But while
Rakhit Khata number 483, petitioner school.
483 plots number are there which relates to alienation case number 37/23. But at page 4, your lordship will find last paragraph, the khata number 8th line, last paragraph 8th line. Khata number is wrongly typed as 480, and on the very next page, page 5 also in para 2 last line, khata number is typed as 480 instead of 483. That is why the present IA has been filed.
IA number 12880 of 2024. There is an application for correction of the modification of the order dated 18/9/2024. Mr. Patnaik and counsel for the petitioner submitted that while disposing of the writ petition by order dated 18/9/2024, so the khata number, Rakhit khata number has been correctly mentioned to be 4 in page number 2. However, in page number 4 and 5, page number 4 and 5, the same has been mentioned as khata number 480, and therefore the same may be corrected. Land and Council for the state has no objection to the same. Therefore, in view of such submission, in page number 4 and 5 of the order also, where the khata number has been mentioned to be 480, the same shall be read as khata number 483. The rest part of the order shall remain unaltered. IA is disposed of. Yes.
Item 43.
Item 43 to 48, my lord, all are similar.
On modification.
से जो कथा हो जो एतरे लॉर्डशिप has directed in first and last 43 and 48 to consider the disposal of the same. I am sorry, my lord, the first and second item are the wrong statement as in made in the first paragraph IA. But regarding 44, 46, 47, 47, in all cases, the lordship was directed to make the compensation payment within a period of 1 month. Originally, after the land acquisition, the original landowners have received the compensation.
No, you go one by one. Don't confuse it.
Why 43 and 48 can you taken off the latter, my lord?
Kuda?
Lordship 43, 48 are last take off.
तापरे 44 कोन
44 lordship can take.
44 टा होची IA number 100 of 24. बाहर करले कौन करा? What modification you want here?
Well, because in this matter, lordship has kindly seen my lord's order at page 13, my lord.
No, what is your modification? Prayer.
Modification, I recalling the order, my lord, because you have not filed any objection or reply, you are not given opportunity of hearing to rebut the claim of the petitioner.
Please come to the prayer, please.
My eyes.
Yes, obviously.
Allow this petition further please to pass approved order and accordingly recall, modify, clarify the order related to particular fact and circumstance of the present case, and further please to pass such other appropriate direction for fresh hearing of the petition in accordance to law, so as to grant an opportunity of hearing to the NHI and protect the loss of public revenue from NHI exchequer funds. Because
why the order will be recalled?
My submission is, my lord, the original after the land acquisition was made in the year 2013. Payment were made to the original landowner in 2014, and thereafter the petitioner is claiming that they have constructed a structure over the NHA land, and the accordingly the collector recommended for payment of compensation without exercising power under section 3G5. Had it been the arbitration proceeding under section 3G5, matter is something different. But here is the case, the recommendation made, the lordship can see the writ petition order itself. They are not able to file any document in support of their claim. The collector file recommendation.
Come to that part of the order.
My lord.
18/9/24 कौन order recall कौन होगा सर?
The lordship can see page 13. Impugn order, sir, IA order dated.
Modification letter. Modification माने it's a small thing, not that you are not praying for recall of the order.
I file first recall of my first and lordship subject to my lord's risk.
Yeah.
But because the petition has not entitled to any compensation. There are 21 persons. Other petitions also filed same order they have taken without hearing us. Your lordship page 13 long counts, page 13 my lord placing of the IA. For a middle.
No, you come to the this order was passed
on 18/9/24,
right, And you are appearing for whom?
I am appearing for the NHI, my lord. Opposite party of 2, my lord.
Opposite party number 2, Amitabh Das was there.
Without instruction, my lord, friend has appeared. Assistance is given to my lord. That's why this
No, assistance it is up to you. When you remain present, and in your presence this order has been passed. If there is any, you can challenge it in the higher forum. So CA तांकु काइंडली सुनी कि नहीं ऊपर मत्ते काइं order recall. That is not a ground to recall the order.
No matter what, in the meantime, they have appointed me and under my lord friend Mr. Divedi as the standing counsel for the NHI.
Challenge the order that
No. On the day he was there or not?
I am not there, Mr.
No, he was there. Mr. Amitabh Das was there or not?
And we are told by the past that he is the only counsel.
No, my lord, lordship can see the NHI has appointed me as the standing counsel for the NHI, my lord. That is a wrong notion.
That is a matter between you and the NHI is to look into it. In the presence, it has been passed, the order has been passed. Maybe because another council is engaged by the NHI in the meantime, that cannot be.
No, I am not saying so. Lordship can see. There is now the NHI, that's why appointed me and my lord friend Mr. Divedi as the standing counsel on behalf of the NHI. My submission is only, my lord, regarding first and the last item, the 43 and 48. The lordship as director for disposal of representation, I will not press that. I will dispose of the same.
44, 45, 46 and 47. IA dismissed. है ना जो modification है ना.
And you lordship permitted to withdraw 43 and
just a minute.
Permitted to withdraw to liberty to dispose of compliance matters.
Dismissed. And IA number one, so jo 48 or 43, 3 rachandi, he wants to withdraw the interim application.
May I place request of lordship to subject my alerts for himself. Since my lord Mr. Das has appeared on
internal कौन यूजी ताकू को कुआनो.
internal lordship will see
सुनी कि नहीं हमें order रख कला पर आगे तांकू कहीं सुन ले हमू
नहीं मुझे सेकंड था lordship का ज़्यादा
नहीं अन्य केस रे भी सही आउची माने
नहीं other day my lord I have got my lord's notice. Your lordship says you file application, thereafter will consider, thereafter you file all the applications. Your lordship will file moment.
Please, yes, item number
49.
Fairly sir, or that with liberty my lord to comply.
Yes,
43 and 48 is permitted to withdraw to comply my lord's order.
43, 48 withdraw. Yes, next. 49.
Item 49, my lord, I am supposed to file the rejoinder, my lord. I pray some more time to file.
You are for the Union of India?
Yes, my lord.
You want to file the rejoinder?
Yes, my lord. Last time the counter copy has been served and I took time to.
Just a minute. All right, the London Council for the petitioner submits that the petitioners intend to file a rejoinder affidavit to the counter affidavit filed on behalf of opposite party number 1 on Tarjami Behra, and some time may be granted. 2 weeks time. 2 weeks time may be granted. Put up this matter. After date fixed up for the rejoinder affidavit be filed in the meantime, serving copy on the London Council for the opposite party. Hello?
Interim order to continue.
Password.
My lord, interim order to.
Interim order अच्छी क्या होगी? Interim order.
One line observation I will not see that since my council for the NHS has appeared. That's why we will not can be entered. One line observation that will be protect also helpful me to.
अच्छा, so you let it since the sworn to Amitabh in the presence of the Mr. Amitabh Das, the Lawrence sworn to, and if we don't find any reason for modification of the order according to the prayer is rejected. So far as this item number 44 to 47 is.
Pass over item number 18.
अच्छी
25th, because of that cyclone situation, a special bench is required to be conducted because Lordship and Honorable Justice Nursing to sit because so torrents are there in the Cuttack town and also some drainage problems are there. So only 10 to 15 minutes Lordship should sit in 4 p.m. so that it can be solved. So kindly constitute the bench because of the urgency. Otherwise, you would approve it. Only 10 to 15 minutes.
Mr. Das, the CMC council is to be told.
I will intimate Mr. Naik.
Just
I will intimate Mr. Naik and also government advocate. I will intimate
Mr. Patnaik.
Mr. Patnaik. Only 10 to 15 minutes because only 1 or 2 issues are there.
ଯୋଉଟାକି ପହରଦିନ ଅଛି ବୋଲି
24 ରେ ମେନଟ also ହବନି ସେ କୋର୍ଟ
ଗୋଟେ ମେମୋଟେ
ମୁଁ ମେମୋଟେ ଲେଖି ଦେଇଛି ଦେଇଛୁ ସାର୍
ମେମୋଟାରେ କହିଦେବେ ଟାଇମ୍ ଲେଖି ଦିଅନ୍ତୁ 3:30 ଆଜି 3:30 and give intimation to the DR list to list this matter and Justice Nursing को intimation देवे the bench probably so that perhaps he is sitting in single bench or something and nodal officer हिसाबरे RG को जणे देवे है the matter is to be taken up at collector करो nodal officer सी रहिबे हाँ ताकू एवं DCP CMC commissioner appear through virtual mode है ना all the persons should appear through the virtual mode है ना 3:30 हाँ ठीक है मेमो डाल
सर केवल सर 15 मिनट्स गोटे दिटा आइटम आई एम ग्रेटफुल माय लॉर्ड
The criminal appeal, I had filed an IA on the ground that the father of the appellant has expired on 18th. So I also submitting the copy of that. Already served to the state.
IAC through the instance Kali yes. For some other bench. Item number 1. Okay.
Supplementary list, item number 2.
May I please your lordship?
May I please your lordship?
May I please your lordship?
I am appearing in criminal number 391 of 2014 my lord through virtual mode my lord. Your lordship, last occasion, your lordship directed by virtue of order dated 13/9/2024 to take instruction with regard to the conduct of the present appellant after being released on interim bail at the last time. Order dated 13/9/2024 man.
IH Burighat.
Yes.
Mr. Tripathi.
Yes, ma'am.
We granted him interim bail for a period of 2 months.
Yes.
As per the order dated 21/5/2024. And we wanted to know what was his conduct during that period. You have not given it. You have given that ଯେତେବେଳେ ଆଗରୁ ଯୋଉ interim bail period ଥିଲା ସେତେବେଳେ nothing adverse was found against it. What about this period from he was released on by the order dated 21/5 24 तो तापर से जो 2 मासर कंडक्ट कोन आसिला
That was
लास्ट लाइन टा देखंतु आप
Yes, during interim period,
it doesn't cover that period.
16 27/4 ରୁ 12/9/16 27/18
this period is not covered so that is why
Yes,
you obtain the instruction
Yes,
Lekhun. Though the Land and Council for the state has produced the written instruction dated 17/9/2024 from IIC Purighat Police Station relating to the criminal antecedent, so also the conduct of the petitioner during the period of interim bail. However, there is no mention about his conduct during the interim bail period, which was granted on as per order dated 21/5/2024 in IA number 201 of 2022. The Land and Council for the state, can it be taken up next week?
Next week.
Submit that the matter may be taken up next week so that he will obtain the necessary instruction. This is taken on this. Whether seal money in the phone.
I am in 391.
The next with like them.
It's very same.
Yes, sir.
Item 3.
My lord, in this case, the copy of the depositions I have not served to the Learned Council for the state. I humbly pray by tomorrow I will serve the copy of the depositions. Let it come any day.
Council IA number so and so. This is an application for appellant number 2. Land Council for the appellant submits that he will supply the deposition copy of all the witnesses examined in the land trial to the Land Council for the state during course of this week.
By tomorrow I will serve copy.
You want the matter to be next week or a week after?
Next week, my lord.
Next.
My lord, date may be fixed.
Next week, at least
My lord, my lord.
commencing as
My lord.
Item 4. मेरा फाइल है IA for further delay.
What is the delay pointed out by the stamp reporter?
Yes, yes, yes.
That is 57 days of his notice. Like
Yes.
IA number 1 is an application for component delay. The stamp reporter has pointed out that there is a delay of 57 days in filing of the after hearing the Land Council for the appellant, Land Council for the state, going to the government taken in the interim application, and since it's a case where the petitioner has been sentenced to life imprisonment, we are inclined to condone the delay, and the delay is condoned. I admit call for the trial court report. Yes.
Item 5.
Item
5, I pray for an adjournment also.
IA number so and so. This is an application for bail and counsel for the petition appellant. 6 for an agenda. Here.
Published.
Item 6.
Item 6, I'm solving the copy of the
Equation. The Land Council for the state in court today, it takes some time to go through the same next
Item 16.
16.
ଏଠିକି ପଳେଇବ ପେପର ବୁକ୍ ଏଲସିଆଟା ଦେଖିଦେବ ଏଲସିଆଟା ଖୋଲିଦେଇଛି ହେଲା ଦେଖିବ ହଁ
Yes, ma'am.
May I please, Your Lordship? The appellant is charged under section IPC and convicted under section 302 of IPC. Sentenced for RI for life and to a pay of fine of rupees 20,000, and in default of payment to fine to suffer a RI for 4 months. In order to establish, prosecution has examined 16 witnesses, Your Lordship.
Just it is to be Chandana Tripathi.
Yes, sir.
One person face trial.
Yes, Your Lordship.
Okay.
He's the husband.
Husband of the deceased.
Yes, Your Lordship.
So please come. Let us know that.
It's a handwritten ODI, Your Lordship.
May I read?
Please read it.
ନିବେଦନ ହେଇକି ଆମ୍ଭେ ଏତେଲାକାରୀ ଶ୍ରୀ ଭିକାରୀ ଚରଣ ସାହୁ
Is
ପଞ୍ଚ
PW?
PW3, Your Lordship.
PW3.
Yeah.
He's the informant father of the deceased.
ଭିକାରୀ ଚରଣ ସାହୁ ସୁଆଂଶୁ ଆଜି ଅର୍ଥ ଏତଲା ଦେଇ ଜଣାଉଅଛୁ କି ମୋର ଝିଅ ମାଣିକ ସାହୁ ବୟସ ସୁଆଂଶୁ ଆଜକୁ
ମାଣିକ ସାହୁ.
ୟେସ୍ ଆଜକୁ 10 ବର୍ଷ ତଳେ ସ୍ଥାନୀୟ ଭଗତପୁର ଗ୍ରାମର ପଦ୍ମନାଭ ସାହୁଙ୍କ ବଡ ପୁଅ ପଦ୍ମନାଭ ସାହୁ PW2 ମିଲର
ପଦ୍ମନାଭ ସାହୁ PW2.
ୟେସ୍ ପଦ୍ମନାଭ ପଦନ ସାହୁ ଅଛି ତ ବଡ ପୁଅ ବଂଶୀଧର ସାହୁ ସହିତ ୟେସ୍ ବିବାହ ସମୟରେ ଦାବି ମୁତାବକ ଡିମାଣ୍ଡ ବାବଦରେ ନଗଦ 50,000 ଟଙ୍କା ସହିତ ବରକୁ ସୁନା ଚେନ୍ ସୁନା ମୁଦି ରଙ୍ଗୀନ ଟିଭି ଗଡରେଜ ଫ୍ରିଜ ଫ୍ୟାନ ପଲଙ୍କ ସହିତ ସମସ୍ତ ଉପକରଣ ମାନ ଦିଆ ହୋଇଥିଲା ଓ ମୋ ଝିଅକୁ ମଧ୍ୟ ସମସ୍ତ ସୁନା ଅଳଙ୍କାର ମଧ୍ୟ ଦିଆଯାଇଥିଲା। ମୋର ଝିଅ ମାଣିକ ସାହୁର 2ଟି ପୁତ୍ର ଅଛନ୍ତି। ମୋର ଜ୍ୱାଇଁ ପ୍ରାୟ ସମୟରେ ମୋର ଝିଅକୁ
ବିଭିନ୍ନ ହେଇଥିବ
କାରଣରୁ ମାରଧର କରେ। ମୋର ଝିଅ ଗ୍ରାମ ପ୍ରାୟ ସମୟରେ ଆମ ଘରକୁ ଖବର ଦିଏ। ମୁଁ ମଧ୍ୟ ସମାଧାନ କରି ଆମେ ମାତ୍ର ଆଜି 24/7/12 ତାରିଖ ସମୟ 1:30 ବେଳେ ଆମ୍ଭେ ଖବର ପାଇଲୁ ଯେ ମୋର ଝିଅ ମାଣିକ ସାହୁ ମୋର ଜ୍ୱାଇଁ ବଂଶୀଧର ସାହୁ ତାକୁ ମାଡ଼ ମାରି ଶାବଳରେ ତାର ପେଟ ଓ ମୁଣ୍ଡକୁ ଭୁସି ମାରି ଦେଇଅଛି। ଖବର ପାଇ ଆମ୍ଭେ ଯାଇ ଦେଖ ତ ମୋ ଝିଅର ପେଟ ଓ ମୁଣ୍ଡରେ ଅଛି ଓ ତାର ସ୍ୱାମୀ ମୋ ଝିଅକୁ ଶାବଳରେ ଭୁସି ମାରି ଦେଇଛି। ସଙ୍ଗେ ସଙ୍ଗେ ମେଡିକାଲକୁ ଆଣିଲୁ। ଡାକ୍ତର ମୋର ଝିଅକୁ ମୃତ ଘୋଷଣା କଲେ। ଏଣୁ ଜଣାଇ କାରଣରୁ ପାର୍ଶ୍ୱରେ ଉକ୍ତ ଘଟଣାକୁ ସହଜା ତଦନ୍ତ କରି ଆମ୍ଭମାନଙ୍କ ଆସାମୀମାନଙ୍କ ବିରୁଦ୍ଧରେ ଆଇନଗତ କାର୍ଯ୍ୟାନୁଷ୍ଠାନ କରାଯିବା ସହିତ ଚିରପୁର।
What are the materials in the petition?
There are no eyewitness, Your Lordship, and surprising, Your Lordship, none of the eyewitnesses have been examined.
No, eyewitnesses are not there.
Not there, Your
This is
Lordship.
based on circumstances.
Circumstantial evidence.
What are those circumstances?
Circumstantial is only the 313 statement where he has admitted that I have killed my wife. But that is also, I would like to draw your
No, it's
attention.
all right. Just tell us, then we will hear it. 313 statement, there is admission.
Yes, Your Lord.
Then what is there?
And other thing is that, Your Lordship, this accused father, he has stated that on hearing the halla, me and my wife went to the room and we saw. Other than that, we saw that deceased is lying on the ground. Other than that, and the accused is locked in another room. Apart from that, there is no evidence to show that the husband has killed the.
No. She was your wife, and both of you were found in one room.
Yes, Lord.
No, Lordship. That is the statement of mother, but who has.
Let's see that. So, okay.
That was the statement of the mother of the accused, but she has turned hostile, Your Lordship.
No, there is no dispute about the homicidal death.
No,
Right?
Your Lordship.
Okay, homicidal death, no dispute. Who is their doctor?
Doctor is PW 13.
PW
13 PM doctor, yes.
See, PM.
Yes.
So, that weapon was found in that room itself.
Yes.
Weapon, what type of weapon?
It is not a sapper, it is like a
crowbar.
Hansakala. Something in Odia, that is. That's good.
Program.
Iron rod, it was.
Iron rod.
Yes, Your Lordship. And no fingerprints have been examined, Your Lordship, from that weapon of offense.
Okay, the marriage as it seems from the FIR
10 years
took
back.
place 10 years back. Right?
2002, Your Lordship.
Any issue out of wedlock?
Two sons. One is of 8 years and another 9 years.
Sons. Have they been examined?
No, Your Lordship. Not even the family members have been examined who were adjacent to their room. They have also not been examined.
What about the statements of the father, mother, or other family members of the deceased about this torture?
Regarding torture, they have not said only the demand of dowry. And there was a quarrel between the husband and wife and at times they have come to compromise it. And now the dowry part is not over here, Your Lordship. Demand of dowry. He has been charged only under 302.
No, dowry, obviously, that time period.
Exactly.
10 years.
10 years after 10 years. That is. There are 16 is Your Lordship.
But Mr. Tripathi,
yes,
you and she also told that she admitted that to have committed the murder. So please come to that question
yes,
which has been put to him. Question number 14.
Before that, Your Lordship, may come to question number 9.
No. See it was the last question. Page number 28.
Yes, Your Lordship. First he has stated nahi, then it has been written कि ମୁଁ ମୋ ସ୍ତ୍ରୀକୁ ନିଜେ murder କରିଛି.
ମୋର ସ୍ତ୍ରୀକୁ murder କରିଛି ପୁଣି ନାହିଁ ଲେଖା ହେଇଛି କଣ?
ନାହିଁ ସବୁ ଯାକ ନାହିଁ
ଥିଲା
ଲେଖି ଦେଇଛନ୍ତି ବୋଧେ।
କିନ୍ତୁ ଏଇଟା
No, initially he has written nahi.
ମୋ ସ୍ତ୍ରୀକୁ ହଂସକଳାରେ ବାଡେଇ ତାକୁ ମାରିଦେଲି।
ଏଇଟା ଗୋଟେ।
Question number 9 ମିଳିଲା।
That means ये सेशन जज आगुरु फिल अप कर ଦେଇଥିଲା ନା?
ହଁ ନାହିଁ ସବୁ।
ଅଦ୍ଭୁତ ସବୁ କଣ ସବୁ
And there is no signature to that also after the correction.
କାହିଁକୁ କାଟିଛନ୍ତି?
ଦିଟା।
ସିରିୟଲ ନମ୍ବର 9 ରେ ଏଇଟା କାଟିବେ।
ମାନେ ଆଟଲିଷ୍ଟ ଆପିଲ ପ୍ରିଫର ହବ, ଆପିଲେଟ କୋର୍ଟ ତାକୁ ଦେଖିବେ, ମାନେ that means this implies that he has not perhaps ये सब क्वेश्चन जो पचारिया कथा जेमती गोटी गोटी क्वेश्चन से पचार कौन पचाई बस दीटा लाइन okay please come to the let us go to the evidence what he has been.
PW2 Miller, father of the appellant.
Who is PW1?
PW1 is the elder father of the deceased.
He has not supported, he has turned hostile.
Yes, ma'am.
Right, hostile.
Except the fact that sometimes the in-laws of Manika used to quarrel with Manika. Manika was brought to medical. In the medical, I saw her dead body.
Sometimes the in-laws of Manika used to quarrel with Manika. That's not specific about
No, not about the husband.
general one. And he has been hostile. Okay.
PW2 is the father of the accused, Your Lordship.
Who is that? Because
The accused is my son. I had given his marriage with the daughter of the informant. At the time of occurrence, my accused son was staying in a separate room with his wife, making me separate from him. At that time, my son and daughter-in-law were quarreling with each other often. I had settled the misunderstanding dispute between my son and daughter-in-law for about 5 times. On the date of the death of the daughter-in-law, she was hale and happy as well as active. Before death, my son and daughter-in-law were brought in their room, which I had seen. My daughter-in-law raised cry in a loud voice, calling Malo Morigali, and hearing such cry, we went to her room. After entering into her room, myself and others found that she had received stab blows of knife on her body near the root of the ear and back with bleeding, and the spot where her dead body was lying was stained with full blood. At the time, my son was inside in another room of that house. By closing the room inside, I took the seized wood in my zimma. That is the zimma nama exhibit 1 by 1 is my signature on it. Now the cross-examination. I was examined by police. It is not a fact that I have not stated to the police the dispute of my son and daughter-in-law for about 5 times, and they were quarreling with each other, and that there was a blood on the spot. I have 2 sons. Myself and both of my sons are living in separate mess each. Accused has gone mad for poverty since 7 to 8 years. Accused used to go out being mad in search of food. I have not seen the murder.
This is informant.
No, he's not the he's the father of the accused.
A father of the appellant.
Accused. Who was present in that just only.
Okay, next 3.
PW3 is the informant, Your Lordship. The accused who is now in the dock is my son-in-law. My daughter died in his house about 8 to 9 months back. At the time of marriage, as per demand, I had given gold necklace, gold bangle, silver paunji, TV, fridge, wooden palanca, and furniture, utensils, and household articles. For about 2 years, she managed to stay in the house of her in-laws. Thereafter, accused started assaulting, ill-treating, abusing, and quarreling with my daughter. Accused used to demand her to part with her gold ornaments so that he can sell the same for his own use. My son-in-law murdered her. On the date of the incident, I got telephonic information about the death of my daughter. I came to the hospital. I saw her dead body and I noticed stabbing, bleeding injuries at her chest, upper part of belly and belly. My villagers had also gone to see the deceased. I was confirmed that my son-in-law murdered her. Exhibit 2 is the FIR. Exhibit 2 by 1 is my signature on it. I was examined by police. MO1 is the joint photograph of my daughter and son-in-law at the time of marriage. Cross-examination. I gave FIR in the very day of incident at Sadar PS at about evening. I wrote in the FIR about the murder caused by the accused giving stab blows. Prior to the marriage, accused was a driver. It is not a fact that after marriage, the accused suffer from poverty. I had not given FIR at the PS about the torture by the accused after 2 years of the marriage. The accused has his father, mother, brother in his family. Till of my daughter, the accused was in his joint family. I had reported about the ill treatment of the accused to his father and others. I had not taken any. This line is not visible.
With me to the house of the accused.
I had not told about the facts of this case to anybody except to his father, now in the court. The deceased daughter has 2 sons aged about 9 and 8 years. It is not a fact that I have not stated to the police that after 2 years of the marriage, and the accused started ill-treating to my daughter, and the accused used to demand her to part with her gold ornaments so that he can sell the same for his own use.
This has been proved through the IU. This
No, Your Lordship.
quotation.
No,
That
Your
means-
Lordship. Not.
And that means she has stated it unnecessarily confronted. All right, next.
It is not a fact that since 5 years the accused had gone mad. It is not a fact that accused has no income and that he has been separated from his parents. It is not a fact that I am deposing falsehood. I have no direct knowledge about him.
5 is the of the FIR.
4 is the scribe.
4 is the scribe of the FIR.
Exactly.
Then 5.
5 is an independent witness, Your Lordship, but who has turned hostile.
Hostile, man.
Then 6.
6 is
So 6
the
is the doctor who conducted the test of the accused, who examined the accused.
Medical officer.
Yes, Your Lordship.
Okay, no external injury. 7.
7 is also a hostile witness, Your Lordship.
Inquest report or signatory. Acha. Then 8.
Yes, Your Lordship.
Yes.
The accused is my brother-in-law. The informant and the deceased are my father and sister, respectively. In 2002, my sister C.DASH had married the accused. At the time of marriage, as per demand, a cash of rupees 50,000, gold and silver ornament, TV, fridge, and other household articles were given to the accused. For some months, my sister lived happily with him, but thereafter the accused started ill-treating her, being drunk. He was employed. He demanded for money from my sister and went on harassing her. He sold away the gold ornaments of my sister. In 2012, accused killed my sister, giving stab blows at her belly and chest. In my presence, police conducted inquest on the dead body of my sister. Exhibit 41 is my signature on the inquest report. I was examined by the police. Cross-examination. I was present when the discussion of demand of dowry was made. The father of the accused had demanded the dowry. My father gave the demanded cash and articles. We had not made any complaint about the demand of dowry to the police prior to the incident. Only I saw the deceased in the medical. I had not seen the incident. Bansidhar had not gone mad after marriage. It is not a fact that for his madness he was not doing any work. It is not a fact that I am deposing falsehood and that the accused is mad. I cannot say when I had given statement to the police. Now,
Next.
PW9 is an independent witness, Your Lordship. I know the accused and the victim deceased to the best of my knowledge. The accused has murdered the deceased, his wife. Prior to the death of the deceased, the relationship between her and her husband was not good. The accused killed his wife by means of a weapon which is local in Odia called as Hansa Kala, one type of iron hinge sharp edge used in ancient time to keep a piece of door leaf straight and intact, which was seized by the police. I have not seen the murder. On the very date of the incident, I gave the statement to the police. It is a fact that I have not stated to the police that, to the best of my knowledge, the accused murdered his wife. It is a fact that I have not stated about the use of Hansa Kala by the accused to kill his wife. The accused became mad after 2 to 3 years of his marriage. It is not a fact that I have no knowledge about the incident. Now, PW10 is the inquest witness who has turned hostile. PW11 is one Brajakishore Sahu. He has also turned hostile. PW12 is the mother of the accused who has also turned hostile. But I would like to place her evidence. The accused is my son. The deceased is my daughter-in-law. I am residing separately with my husband. Accused and the deceased were staying in a separate room. About 1 year back, heard a sound in a loud voice calling Malo Morigali, and hearing such cry, we went to their house and found the deceased body. I do not know how she died. At this stage, she was declared hostile. Now, it is not a fact that I had stated before the police that accused Bansidhar and the deceased Manika was blessed with 2 sons, and that the accused sold away his tractor and that went on eating the sale proceed of the tractor, and that thereafter, out of poverty, he quarreled with Manika, and on the date of incident, the accused closed the door from inside, and that while his wife Manika was asleep, he by means of a pointed iron rod stabbed at her body, causing profuse bleeding injuries, and that hearing her screaming, Kudamani Sahu, Braja Sahu, and Abhay Sahu. Except this Braja Sahu, no one has been examined, Your Lordship. Broke open the door and found the deceased on a pool of blood, to whom they shifted to the hospital in an auto rickshaw, where she was declared dead. And the police reached at the hospital, and in our presence, police conducted inquest over the dead body of the deceased, and I put my signature. But whereas the father had stated that the accused was not inside the room. And
No, this is a previous statement
Yeah.
which he denies to have
stated, Your Lordship. That is that's now she has turned out.
yes.
W13 is the PM doctor, Your Lordship.
PW13. So what sort of injuries have been seen?
On 25/7/2012, I was working as an eye specialist at DHH Jajpur. On that day, on police requisition as per the order of ADMO Jajpur, I conducted PM examination on the dead body of Srimati Manika Sahu, wife of Bansidhar Sahu, at about 12:05 p.m. and found one stab wound, one penetrating wound, one penetrating wound, one penetrating wound. It has continued that way.
Yeah.
One lacerated wound, two wounds, and one stab wound, multiple lacerated injuries, and two stab wound as per the size and location mentioned in my report. The stab.
This recording I do not. It should have been mentioned that in which part of the body.
No, that has been not recorded.
PM report of Harkala.
This is very one penetrating wound, one penetrating wound, one penetrating wound. So the
in judgment, it is there at page 5.
No, I just want to see where is the penetrating one wounds there. Yes, it is clearly mentioned.
Yeah, absolutely.
Stab wound of size should have been mentioned. This portion should have been mentioned.
Nothing has been.
जो भी अपन जाती है उसमें ना Okay, so the cause of death is on account of the stab wound.
Yes, Your Lordship.
Nasi भी लिखा है caused by alarm sound. Cause of death was due to shock as a result of increased vital organ function.
Lungs, liver, and hemorrhage at the time.
Then 14 is the
14, 15, both are the Caesar witness, Your Lordship. And 16 is the IO.
iota version forum.
On 24/7/2012, I was working as ASI of police at Jajpur Sadar. On that day, on the report of informant, Bilas Chandra, SI Bilas Chandra registered Sadar PS case number 80 of 2012 under section 498A 302 IPC, and on his direction, I took up the investigation. I am acquainted with the handwriting and signature of IIC BC Tripathi. Exhibit 25 is his endorsement, while Exhibit 26 is his signature. 27 is the formal FIR, and Exhibit 28 is his signature. I examined the informant witnesses, visited the spot, and prepared the spot map. Exhibit 6 is the spot map, and 6.1 is my signature on it. I seized the sample blood from the floor and prepared the Caesar list. Exhibit 7 is the Caesar list, and Exhibit 7.1 is my signature on it. I also seized one acacia palla and 3 pieces of buddhu of door leaves and prepared the Caesar list. Exhibit 8 is the Caesar list, and Exhibit 8.1 is my signature on it. I also seized collected blood, nail, and hair and prepared the Caesar list marked as Exhibit 9. 9.1 is my signature on it. I also seized the iron rod and check lungi and prepare the Caesar list. Exhibit 10 is the Caesar list, and 10.1. I seized one joint color photograph of accused S.K.Sahoo deceased and prepare the Caesar list. Exhibit 11. 11.1 is my signature on it. I also seized the command certificate, wearing apparels of the deceased, and collected blood, nail clippings, and hair and prepare the Caesar list. But Exhibit 12 and 12.1 is my signature on it. I arrested accused Bansidhar Sahu on 24/7/2012. On 25/7/2012, I conducted inquest on the dead body of the deceased Manika Sahu at DHH Jajpur and sent the dead body for PM examination. Exhibit 13 is the dead body challan, and 13.1 is my signature. I forwarded the accused on 25/7/12 after his medical examination. I sent the exhibit to SFSL for a chemical examination. Exhibit 14 is a forwarding report for chemical examination, and Exhibit 14.1 is my signature on it. Exhibit 15 is the chemical examination report. Exhibit 4/3 is the inquest report and 4/4 is the signature on it. Exhibit 16 is the disclosure statement. 16(1) is my signature.
Thereafter, all this confrontation has been put. That's all. Nothing else is there.
Yeah.
So this actually I was verifying this final for the ASI is the SI of police. Otherwise, the 302 cases, ASI of police cannot investigate. 302
As written as ASI, SI of police.
SI of police. Final form. Say case 8 of 1 plus B. फिर लिखा है SI of police.
On such a
2012 declare that is the problem of SI. So whatever you placed the evidence, one statement
Your Lordship may go to the spot map also.
that is
As per the evidence, the occurrence took place inside the bedroom, but the spot is shown somewhere outside the. That is at page 67. The spot is in front of the bedroom of his younger brother. But as per the evidences of then the statement of the father, it was inside the bedroom of their.
Bedroom of the accused.
Yes, Your Lordship. But the spot is outside.
Spot is outside. This man.
Now, interestingly, 16 stab injuries are there, but not a drop of blood in the.
No, let us see. This inquest must have been held in that spot itself, na? This he said that I prepared the spot map. I visited the spot, prepared the spot map, and seized sample blood from the floor.
Yes, sir.
And prepared the seizure list exhibit 7. And I also see the Akas Palha, 3 pieces of voodoo of the door leaves and prepared the seizure list. So I collected blood so and so of the accused. I also see this. Okay, let us see this seizure list. Spot map spot map exhibit 6
67 page.
Kitchen, building of S.K.Sahoo, bedroom hala, Sunakar Sahoo, thatched house of Krishna-Chandra-Sahoo.
Entrance room, just at the bedroom.
Inquest at the page mark page.
Best is exhibit 4/3. 4/3.
School. Sample block sample blocks use collapse. Conducted impression regulation. Here, headquarters hospital. Small from that.
Jaspur Sadar PS. Place of inquest.
Page is a seat by VIG doing a mark.
At 13. Exhibit.
Exhibit 13 is the dead body shut up. সেটাকে mark করনা actually inquest report you are right, it is exhibit 4 that is what is saw on the at the spot.
Spot is जो seizure list है उसी description अच्छा.
So you see if a particular mark is given in a spot map, it would be hit uh, 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 under section 60. He has no personal knowledge. So he must have prepared on the instruction of somebody else, right? So who is that somebody told him that this is the spot? So
That
merely
is not.
because he has shown it to be the spot, it cannot be said to be the spot. He was not present. So when the IO goes to the spot, he takes the help of others. So the evidence must come. You are right that this bedroom, etc., that can be said that it has been. But once he is marked as a spot, because the dead body was not there. If the dead body would have been there, that matter is different. Dead body was found shifted to the hospital on the next day. So merely he has shown it to be the spot in the entrance room. He has no, it's just it is not can be said that it is spot. So that marking of that it's not admissible that this is the spot. Because the oral evidence, you are right that the oral evidence is contrary to each other.
Exactly.
Because the father of the this man, appellant, says that yes, they were there earlier, but when I heard the cry, I
And when
went there.
he was
I
not there.
found that he was not there. He was just come to that father once again.
PW2.
PW2. Last line of last sentence of paragraph number 1 is very relevant.
Before death, my son and daughter-in-law were together in their room, which I had seen.
Right. So this is then but paragraph 2 first line asundu.
My daughter-in-law raised cry in a loud voice, calling Malo Morigali, and hearing such cry, we went to her room. After entering into her room, myself and others found that she had received stab blows of knife on her body near the root of the ear and back with bleeding, and the spot where her dead body was lying were stained with full blood. At that time, my son was inside in another room of that house by closing the room inside.
Another room,
Not in that same room here.
हाँ जो रूम रे डेड बॉडी पड़ीथिला बा स्टाफ वुंड हेकिनी इंज्योर्ड हिसाब रे बा जाओ पड़ीथिला से रूम रे ये नथिला इट्स ऑल राइट he was in another room and he has closed that room.
Yes, sir.
That was the so but another her the mother of the appellant
PW12.
PW12
Yes, ma'am.
come to that PW12. The deceased, my daughter-in-law, residing separately from my husband. I am residing separately with my husband. Okay. Accused and the deceased were staying in separate room. I heard loud voice, hearing such to the house and found the deceased dead. ଆଉ ତ କିଛି କହିନି ବାକି
I do not know how she died.
ହଁ ନାଇଁ ସେ ଅନ୍ୟ ସେଇ ରୁମ ରେ ଥିଲା ବୋଲି କିଏ କହିଛି?
ଆଉ କେହି କହିନି.
And who are the other family members present in that house?
The brother and
କିଏ
sister.
କହୁଛି ସେ ବିଷୟରେ କିଏ କହୁଛି ଯେ କିଏ ଅନ୍ୟ
Only the spot map is showing you, Lord.
No,
The bedroom of C.DASH, who is the brother.
ଫ୍ୟାମିଲି ମେମ୍ବର ସେମିତି କିଛି ଏଭିଡେନ୍ସ ଆସିନି
ନା.
ଯେ ବାପା ମା ତ ଏକ୍ସାମିନ ହେଇଛନ୍ତି
Like,
ନା
the father said I had 2 sons.
ହଁ ମୁଁ ସେଇଥିପାଇଁ କହୁଛି
The
No, 2
page.
sons of the deceased.
No.
So one of the brother has been examined.
No, you're not.
No.
No.
Deceased brother has been examined.
Deceased brother have been examined.
So you are telling about appellant's brother?
Yes.
Have not been
Who is
examined.
Addison? Who was just the next room where the place of occurrence? He was residing in the next room.
C.DASH.
Sunakar Sahu.
Sunakar Sahu.
କୋଉଠି ସେ କହିଲା ମୋର ଆଉ ଗୋଟେ ପୁଅ ଥିଲା ବୋଲି?
At page 33, para 5, your lordship.
33. I have 2 sons, right?
Myself and both of my sons are living in separate mess. And in the same premises, but in different.
Premises, obviously. ରୋଷେଇବାସ ଅଲଗା ହଉଥିବ ଆଉ କଣ।
Agree.
ରୁମ୍ ସେପାରେଟ, ତେଣୁ ରୋଷେଇବାସ ଅଲଗା ହଉଛି। ଏକାଠି ଗୋଟେ ଛାତ ତଳେ ରହୁଛନ୍ତି, କିନ୍ତୁ
Not the neighbors were also not examined.
no, in this type of case,
We
neighbors
cannot
examination in that way, not because the so far as torture aspect is concerned.
And who broke?
Mostly the father side of the deceased would know it better. Once she goes to the house of the neighbors also, or the neighbors comes, they may also tell about, there is likelihood if the quarrel is in a higher pitch, the neighbors can know it, hear it also. But sometimes, most of the time, they don't support because after all, this man is their neighbor.
Yes,
And even if the daughter-in-law dies, sometimes most of the cases it is in that. But here is a case. Let us say, uh, uh, what are the circumstances if we see that the parents, the father of the deceased and the brother of the deceased, let us say about the torture first, which can be said to be a motive behind the commission. So there was some kind of demand at the time of marriage. Gold necklace was demanded, gold bangles, all these things were demanded.
That demand was by the father-in-law, Your Lordship, not the no allegation towards the husband. The demand was by the father-in-law.
At the time of marriage means 10 years.
It's back.
For about 2 years, she managed to stay in the house of son. Thereafter, the accused started assaulting, ill-treating, abusing, quarreling with my daughter. So this day, accused used to demand her to part with her gold necklace so that he can sell the same. So
for his own.
This is there, my son-in-law, but that is not. On the is after marriage.
There is no evidence so that before the occurrence there was a demand of
No, that is how 4898 is not there, and 304 not the case.
That period is there.
The only thing is that it is not denied that the appellant was not there in the room. Room in the sense where
the premises.
Yes, he was very much present in the premises, and the kind of evidence that the mother of the appellant gives or father of the appellant gives, that we have seen him in a room closed from inside.
Now your lordship has to visualize one thing: 16 stab injuries.
Yes.
Now, is it possible without applying a force? Her. So while applying a force and stabbing her, some blood may be sprinkled on his wearing apparels.
Yes, that is there.
Where
That
is
there in his lungi.
No, it's
Yes,
not
sir.
there. Blood moderate, human, blood group, no opinion. And it
No,
has
that
been...
is deteriorated as it is.
So for that, I cannot be held responsible.
No, you are the husband. You are present in that very room. We accept your father and mother, and of course, two minor children.
They were never examined.
No, it's not examined. It's a matter. Then the your wife made a homicidal death, and it's not that it's a mason type of house. It is a small house where the rooms are very close to each other.
Exactly.
Okay, so you are the best person to say that how your wife received so much of stab wounds, like which are 16 in numbers, and rather when the questions have been asked to you, at two places at least you have said that yes, I have committed the murder. So
that also doubtful, your lordship, because initially he has stated nahi, then he has stated
nahi, that is exactly what we say, that it's a blunder, we can say, that has been committed by this judge.
And even after changing of the statement, there is no signature to that.
No, even if he would have said nahi, then also it would have gone against him. The reason being, it is not expected that when the wife is going to be It's not a single blow that someone will come inside the room and push the or penetrate the knife and go away. So might be that if the person would be in another room, could not have seen it. But it is not like that. Several injuries are there. That means
And
the
when she
culprit,
shouted, they came. That means the continuous process was going on.
they have
So
seen
they could
that.
have,
They have seen that.
but there is no evidence to show that they
It
could have
is,
resisted.
it is not expected that the parents will come on the way and they will be speaking about the
No, there are
son.
outsiders also. They were there,
That is there.
but
Where is that?
they have not been examined.
That
That is unfortunate. They have not been examined. And one who is examined, he has turned hostile.
the whole evidence is like
16 stab wounds inside the
all are penetrating.
house, and you are you are present, and you are. It is your somebody has given that stab wound.
Yes.
Either
In that
it is
case
you or any of your family members. If it is your case that no, I have not done it, then either my family XYZ has done it or some outsider came,
Yes.
he stabbed, then you should have said, taken that plea in the accused statement.
That part is
Because
silent,
that,
Your Lordship.
that burden shifts to you in view of 106 of the Evidence Act. So if you, instead of explaining, you say that yes, I have committed the murder, and the other circumstances like your presence in the scene of occurrence, and you are in that very room as the for the statement of that your father, what hostility they have got with you to tell that yes, they could have told that no, our son was not there in the house. They could have told no, our son was there in that house very room. ତେଣୁ ଆପଣଙ୍କ ବାପା ମା କାହିଁ ଆପଣଙ୍କ ବିରୁଦ୍ଧରେ କହିବେ?
The father that he was in a separate room.
No, father
Room
stated
could be
that
separate.
before
They
Before
had
he had seen both
He had
of them
seen.
together,
Yes.
but after the occurrence, he was not
He
there.
went away. Huh.
The moment he entered, he was not there.
ଥରେ ଥିଲେ ପ୍ରଥମ ମରିବା ପୂର୍ବରୁ ଆପଣଙ୍କ ବାପା ଦେଖିଛି
ଦି
ଯେ
ଜଣ
ଆପଣ
ଥିଲେ।
ଥିଲେ, ଆପଣଙ୍କର ତାଙ୍କର ଯୋଉ ଆର ସ୍ତ୍ରୀ ବି ଥିଲେ।
ଆଜ୍ଞା।
ତେଣୁ ତାପରେ ଏଇ ମର୍ଡରଟା ହେଇଛି, ପାଟି ସେ ଶୁଣିକିନା ଆସିଲା ବେଳକୁ ଆପଣ ଯାଇ ଆଉ ଗୋଟେ ଘର
ବାସ୍।
ଭିତରେ କବାଟ ବନ୍ଦ କରି ରହିଛନ୍ତି। ତେଣୁ
No, when he entered,
XYZ ଯଦି ମର୍ଡର କରିଥାନ୍ତା ସେଭଳି ତ କେସ୍ ହିଁ ନାହିଁ। ତାହେଲେ ରାଦର ୟୁ କୁଡ୍ ହାଭ୍ କମ୍ ଫରୱାର୍ଡ ଟୁ ପ୍ରୋଟେକ୍ଟ ୟୁର ୱାଇଫ୍, ରାଦର ଆଉ ଗୋଟେ ରୁମ୍ ଭିତରେ ପଶିକିନି
ନିଜେ ବନ୍ଦ କରିକି ରହିବା ମାନେ କଣ?
ରହିବା, you are not explaining anything, rather admitting that yes, you have killed your wife. So how do you overcome that?
that part is silent.
So two aspects which is required for the prosecution to prima facie prove is the homicidal nature of death and the other circumstance.
Yes.
So these are the two circumstances which clearly justifies the prima facie case. Now that is how the matter shifts on you to explain how it happened.
Because if you say that no, any of my family member has
Yes.
committed the murder, not me, that plea is not there. So you are not taking that plea. And even there is no evidence also, positive evidence has come that apart from you, your father and mother, and maybe your children, any other family members who are present. Though the father has stated that I have got a son, that means he has got a brother of this, but that brother was even present, stated by him,
Nowhere it was stated.
nor brought in the evidence also. ତେଣୁ ଆପଣଙ୍କର ସ୍ପେଶାଲ ନଲେଜରେ ରହୁଛି ଯେ ଆପଣଙ୍କର ସ୍ତ୍ରୀ ଯେ କି ଆପଣଙ୍କ ସାଙ୍ଗରେ ତାର ମରିବାର କିଛି ସମୟ ପୂର୍ବରୁ ବା ଷ୍ଟାବ୍ ୱୁଣ୍ଡ ରିସିଭ କରିବାର କିଛି ସମୟ ପୂର୍ବରୁ ଗୋଟେ ରୁମ୍ ଭିତରେ ଥିଲା ଏବଂ ତାର ଚିତ୍କାର ଶୁଣି ଯେତେବେଳେ ଆପଣଙ୍କର ବାପା ମା ସ୍ପଟକୁ ଆସୁଛନ୍ତି, ଦେଖୁଛନ୍ତି ସେ ପଡିକିନି ରହିଛି, ଷ୍ଟାବ୍ ୱୁଣ୍ଡସ୍ ଗୁଡାକ ରହିଛି, ସେତେବେଳେ ଆପଣ
ଆଉ ଗୋଟେ
ରୁମରେ କବାଟ ବନ୍ଦ କରିକି ରହିଛନ୍ତି। So ye ଗୋଟେ conduct, non-explanation is another conduct, previous assault, torture, that is, and
admitting the fact.
homicidal death and admission. तो ये जो 5-6 जिनस आसिला that forms the chain complete. How can you overcome this chain? That where is the missing chain? एथुरे बाहर करियर आउ काई way out कोट अछि जे नाइ जे somebody else might have
Could have been
committed
there,
the
yeah.
murder to commit. Neither it is your plea nor there is anything on record. Rather, everything clinches that the against you that you have committed this.
Other than that, this is
Give it to it
2012, Your Lordship.
It's normal.
Almost 12 years in custody. Almost 12 years in custody. So,
Can you improve any way?
Your Lordship may give me one more hearing. I'll try. Your Lordship.
This is the discussion we made, and have you studied in the line that if the accused admits in the
I'm looking for some judgments, Your Lordship. That is why I'm saying.
the threatened statement रे यदि गोटे accused admit कला, let us say, but the other evidence is not that
Yes,
clinching.
yes. But here it is.
Other evidence is not clinching. Admission one thing. Other evidence clinching.
Admission is other.
Shall I examine question?
I'm looking for some judgments, Your Lordship.
Because କେତେ ଗୁଡାକ judgment ଅଛି ଦେଖିବେ ଯଦି evidence ନାହିଁ total
There is exactly.
but
There is an old judgment, so I'm just trying to find out that one.
but ଅଛି material addition এটা ଗୋଟେ additional factor ହିସାବରେ କାମ and not once you have this as it appears twice you have stated in that 313 statement
9 and 14.
9 and 14.
And as you say, had he rectified his statement, then normally it is written that he again said.
Exactly.
It is not that.
That
there is
evidence is not. That is what I'm saying.
Actually, ये नाइट ऑफ काटी गले से नाइट ऑफ काटी ना दी
फास्ट सब जाक नाही लेखिरी छाड़ देले
तापरे गोटे लाइन पछी
Now, these statements and depose we correcting, that has to be also seen.
No.
Now that goes in benefit of doubt to the accused, Your Lordship.
That way we cannot.
He must have to come on the dock, and this has been confronted to him, but invariably it.
से माने ordinarily कौन हुए कि जे सब गुड़ा को से डिफेंस लॉयर कहि दी जान से बेले बेले से माने प्रेजेंट ही रहती नहीं जेतला एक्यूज स्टेटमेंट जा पचारियो कहू नाही तो से ये कर दियंती अच्छा सी सेशन जज ताकू लेखंती केतोडा जस्ट 2-3टा फॉर्मल क्वेश्चन पचारी कोटा नाही ए डाक्टर एविडेंस मु जानी नी जोडा को साइंटिफिक ऑफिसर या कहउचंती लिख देबे मु जानी but in fact law requires that all the questions are to be put whatever incriminating but this is done by some not by
invariably it is done everyone does
but this thing should ijuta jaha karichandi it should not be like that माने जदि आपणकर माने नाहीटा गोटे जगह काटिले सिग्नेचर पले आ गोटे नाहीटा काटी दी था एटलीस्ट सिग्नेचर से रही था शॉर्ट सिग्नेचर सेटा को मध्य
Short signature is also not there.
नहीं नहीं लास्ट ईयर नहीं रे सिग्नेचर नहीं पट्टा है कि
पट्टा भी हेनी कि सिग्नेचर
सेटा
14 टा
तेणु सेटा हे जाउची मो स्त्री को निजे मर्डर करिछि
नाहीटा फॉलो अप रे पूरा अछि इन वन लाइन
नहीं से अछि तो ना टेक्निकली चली
गुड लाइन ने
हां तापरे से भूली जाई जे मुडा नाही लेखि
I'll cite some judgments. Your
You
Lordship.
just, it's a question of somebody's life. So we can take up tomorrow?
Monday, Your Lordship.
No. Chandana Tripathi. Says
Miss, Your
Miss
Lordship.
Chandana Tripathi, Learning Council for the appellant, and
Guru Pilla.
Mrs. And Mr. Priyavrata Tripathi, Learning Additional Standing Counsel. After placing the evidence of the witnesses, the Land Council for the appellant seeks for an adjournment till next week to cite some decisions put up this matter on 28th October 2023. So that's part hard for the So the other bench will function.
Yes, ma'am.
So we are rising.